Yes,
Yes.
Lordship. Yes, I bet mass item 22, Lordship.
42,
22, Lordship.
22.
Bell hearing column, Lordship. Diary was called for, Lordship. Diary is not.
the not received.
Actually, let's see that after vacation, Lordship. We'll see.
It's submitted.
The charge sheet submitted.
Yes,
please.
then I will approach before Lanet
Ah.
for trial compression.
The learned APP has submitted that the charge sheet in this matter has been submitted.
Right, CS number
Hmm.
254/25, dated 28/11/25.
Counsel appearing for the petitioner has submitted that this bail application may be closed, allowing him the liberty to approach the trial court.
Yes.
Liberty is granted. Bail application closed.
Obliged, Lordship.
May I please, Lordship, I beg to mention item 39. I'm on the vacation manner. Order. I'm for respondent manner.
It is his IA. Your IA.
I for
Cancellation for bail,
Cancel-
matter. Cancellation of bail manner.
bail objection, cancellation of
So he wants it after the vacation. At the request of the learned counsel appearing for the respondent and not objected to by the additional PP. Is this matter again on 19th of January or 5th? Your choice. 19th of January.
May I please, Your Lordship?
Yes.
Mention item number 16 and 27. We are filing our affidavit today, Your Lordship. It may be called for.
Yes.
Item 27, we also,
Items 16 and 27.
Yes, Your Lordship.
Huh.
16 and 27, we are filing.
27,
affidavit.
there for
The petitioners for item number 27.
seek time for reply.
Learned counsel appearing for the
January 1st.
in
it possible.
27 you read, huh? Learned counsel appearing for the customs department has submitted that they are filing an affidavit today. Objections today. Learned counsel for the petitioner has sought for a short accommodation. Is this matter again on the
8th of January.
Huh?
8th of January.
8th,
Lordship, it would 9th of January would be fine.
9th of January.
Highly obliged. May I please, Your Lordship? I
And in the other one, in item 16,
16 after some time.
after we'll call for the objection. 16 of objection filed by Shakul. Yes.
I beg to mention for listing of a regular bail application, Lordship. Only on Friday.
Asena senior bench is there.
August.
Fabulous, Lordship. I beg to mention item number 26, Lordship. Pass over for the day, Lordship. The senior is not well today, Lordship.
Learned counsel appearing for the petitioner has prayed for a
After vacation, Lordship.
accommodation today. Place this matter again on the 5th of January 2026.
Obliged, Lordship.
May it please, Your Lordship. I beg to mention item number 8, Your Lordship.
8. Yes.
The other side has already been obtained, Your Lordship. So I pray that the matter may be taken up after vacation, Your Lordship.
Date may be fixed, Lordship.
19th of January will do.
19th of January, Lordship. Lordship.
At the request made by the learned counsel for the petitioner with the consent for the learned counsel, with the consent of the learned counsel for the respondent. Place this matter again on the 19th of January 2026.
If there is an interim order, that may kindly be.
Interim order passed earlier shall continue.
Deeply obliged.
Deeply obliged. Yeah, please, Your Lordship. Lordship, I beg to mention item number 23. Lordship, the item may be passed over for a day, Lordship.
At the prayer of the learned counsel appearing for the petitioner. Place this matter again on,
On 10th, Lordship.
on
On 9th, Lordship.
9th year overfull. 19th.
Please, Your Lordship. I beg to mention item 33 minor.
33.
On interim minor, case there has not been received minor.
So so appears for the petitioner. Huh?
Yes, my
Up to the city, not to city.
The up-to-date CD is yet awaited. Is this matter again on the 19th of January,
My lord.
2026. In time order passed earlier to continue.
Published, my lord.
Please, your lordship, lordship, item number 31.
31.
Yes, lordship.
Huh?
It's a matter is infectious, lordship.
Influxus in the sense he has been taken into custody. Ms. Swenson and the council appearing for the petitioner submitted that the petitioner has been taken into custody and therefore this anticipated bill matter may be closed, full stop. Accordingly, anticipated bill petition is closed.
Hey, please, your lordship. Lordship, I beg to mention item number 15, my lord. May come up after vacation, my lord. The engaged counsel is out of station, my lord. Mr.
The
N.
Learned Counsel appearing for the petitioner has prayed that the matter will be taken after vacation. Accordingly, list the matter again on the 21st of January, 2026.
Keep your lordship.
Yes, sir.
Yes, item number 9, my lord.
CD was there,
No, no, item number 15 city not there, 21st of January.
21st of January. Yes, sir.
Item number 9, in concern of both the parties,
Hmm.
matter may be taken after vacation, my lord. And I'm allowed to furnish a face copy, my lord.
Mm-hmm.
Face copy of the petition, my lord. There was defect in the copy, my lord.
Okay.
Incomplete petition was there.
At the request of the Learned Counsel for the parties, list this matter again on. We'll have it on 27th, sir. 27th of January, 27th of January, 2026.
Interim order is there.
Interim order passed earlier shall continue.
Your lordship, I beg to mention item number 19.
19. Yes.
Matter may be adjourned for today, lordship.
At the prayer of the Learned Counsel appearing for the petitioner, list this matter again on
After vacation, lordship.
Any day scan copy, my lord.
30th of January. Yes. বেটা কই আসলে আপনি বেটা কবুল হয়েছিলি
Three, 105.
This court does not find this to be a fit case for grant of privilege or bail to the petitioner at this stage. Bail petition rejected.
One, yes.
We had to reject it.
Previous motion be a item 2.
Lord, I'm appearing on behalf of the council for petition. My lord.
Ah,
In the morning, he faced with some difficulty.
ah.
I've been, my lord, instructed to call for my lord, make a prayer to call for CD, my lord.
Mr. So-and-so, and a counsel for the petitioner, the Learned APP appears for the state. Petition under 483, BNSS 2023 in connection with Jakhalabanda PS case number so-and-so. Call for the CD.
The page 56, my lord, Sasit submitted. Page 56. It is there.
Charge sheet is there, so,
FI number 65, yes.
huh?
Yes, Sasit submitted, my lord.
Accused, where are the accused?
Page 56.
Name of the
Yes.
accused?
My lord, name of the accused will come, but Nagav FI number 65.
It matches.
Yes, Sasit.
Oh, scan copy of the
Yep.
TCR. Scan copy, not call for the CD, scan copy of the TCR, huh? List, TCR, get your DIMCO company suggested.
My lord, 21,
21st.
21.
21st of January.
Obliged.
May please, your
Yes.
Before Lordship takes up this matter, just clarify one thing, my lord.
Ah,
In this case, the co-accused has also filed a bail application.
ah,
And the same has been listed before court number 14 today, my lord.
ah.
There's a notification, my lord, 3rd of May,
which says that bail applications arising out of the same FIR have to be placed before the same bench, my lord.
Yes.
So, my
It
lord,
is-
either your lordship, I'll leave it to your lordship. Whether if lordship takes it up, then I'll mention the matter there.
No, no, let us not break the sequence. List before the appropriate bench.
Sir, may I pray one thing, my lord? This is a BA, my lord, and vacations are coming. If your lordship will fix it tomorrow, my lord, I will pursue it to the registry. Otherwise, this will not come up before vacation, my lord.
List before the appropriate bench tomorrow, since it has been submitted that the another petition regarding the same issue is listed before another bench. Good stuff. List again on 18/12.
Deeply obliged, my lord.
Mm.
Mate, please, your lordship.
Yes, sir.
Your lordship, bail application, FIR is at page number 10, your lordship.
Hmm.
May I read the FIR, your lordship? May I read the FIR, your lordship?
Yes.
Your lordship, here a car was lent out to my husband, and we
Ah.
work as sales agents, your lordship. Thereafter, when we are trying to sell a cult car to the one particular informant here, your lordship, it came out later to us that the person who is the main owner of the car, who has given us the car, is the main culprit, and we wanted to file a joint FIR, your lordship. However, your lordship, in the meantime, as this FIR was lodged, police has arrested us, but on production before the magistrate, your lordship, peruse page number 22, your lordship, the informant appeared before the magistrate, that is the production magistrate, and he has categorically stated that the conception has been clear between us right now that they are not the real culprit. The real culprit is someone else, and on her release, we can file a joint FIR, your lordship. And our contention, that is the informant's contention, is that may I get my money back? I am the accused petitioner. I am the accused person here. I am ready to release all the money whichever they have sent me, because I am not a party to the entire transaction, your lordship. I will immediately release the money, but in the meantime, police has forwarded me. We appeared before the production magistrate, and we even placed our case that release the lady on production bail itself, and she will release our money. We will jointly file an FIR against the main person who is the accused, your lordship. However, that was not reflected, your lordship. Page number 22, your lordship. The informant is also present before, your lordship. Page number 22, third paragraph, your lordship.
Yes, PP, what do you say?
Well, the fact is that the money received by him. And yes, he is a mediator, but that registration number is fixed. So if he is dealing with this business of car, so he must have checked prior to deal.
Indeed. Here I am the wife, your lordship. I am not the husband. I have not yet applied bail for
The
the
wife
husband.
of
I am
the
wife. I will
person
release
who
the
was
money,
selling
your
it.
lordship. Indeed. I am
If
the wife. I am
he is
selling it.
allowed, then she can return the money. Once the money is returned,
And she can file an FIR also, your lordship, for the proper investigation, your lordship.
Hmm?
You will file an FIR along with the informant, joint FIR, your lordship. The main culprit came to the police station, your lordship, but unfortunately, any FIR was not registered against the main owner of the car, your lordship. That is another issue.
the buyer and the wife of the accused, I think. Huh?
Well.
But dispose this of what will. It is not AB.
It's
It's
an
BA.
BA.
She's members. Well, let her come. Let us see what maybe she can aid the investigation to some extent. You are appealing for anybody?
Your lordship.
What do you say?
I agree, your lordship, because only when I told them, they were also able to find out. So they have agreed to pay me the money. So when she gets out, she pays me the money, and then we can take action against the person who has started this whole mess, your lordship.
Hmm. But Mr. Sonsula Council appealing for the
Accused petition.
accused. Also the learned
Forwarding
APP.
to Malat, details against the Malat wife.
Lady is not there. Hmm?
Not there.
That is what I had personally seen. Nothing against her, yes. Mr. So-and-so appears for the informant on prior notice by the accused. It has been submitted by the counsel for the petitioner that an FIR had been lodged regarding the sale of a vehicle. And although the husband of the petitioner is a broker, is a
Sales
bro-
agent.
is a sales agent, comma, the present petitioner is not in any manner linked to the to any transactions which occurred between the husband of the petitioner and the informant. The learned counsel for the petitioner has submitted that although there was a transaction of money between the husband of the petitioner and the informant,
The money was transferred to the wife's account. That is the transaction. The wife's account
there was
was-
some transaction, the money had been deposited to the account of the petitioner. And given an opportunity, they're ready to refund the money received and further participate in the investigation, full stop. It is the case of the petitioner that the owner of the vehicle had committed some fraudulent activity due to which the present petitioner and her husband is taken into custody on an FIR lodged by the informant. Mr. So-and-so learned counsel appearing for the informant has submitted that he would have they had intended to file a joint FIR against the original owner of the vehicle, but the same could not proceed because the present petitioner and her husband had been taken into custody. Full stop. The learned APP has submitted that the forwarding report does not reveal any act on the part of the present petitioner per se. Full stop. We have gone through the documents annexed with the bail petition. It is in the facts and circumstances. This bail petition is allowed and it is directed that the petitioner, namely so-and-so, shall be released on bail on furnishing a bond of rupees. What was the amount you took? 7 lakhs.
7 lakh.
On furnishing a bond of rupees 25,000 with one surety of the like amount to the satisfaction of the
Chief Judicial Magistrate.
Chief Judicial Magistrate, Kamrup Metropolitan, Guwahati. Full stop. It is made clear that the present application has been granted the privilege of bail on the assurance that they would participate in the investigation proceedings, and because the informant does not have any and has not raised any claim against any claim of fraudulent activity against the present petitioner. Full stop. The release of the petitioner on bail shall also be subject to further conditions, which are 1, 2, 3, 4, 5.
Deeply of that.
Bail petition accordingly disposed of. Yes, sir.
Bail application, Your Lordship, Ijar, Your Lordship, page 7, Your Lordships. There is a consensual relationship between the girl and the accused, Your Lordship. Thereafter, they have in the house of the parents now. They have no any dispute, Your Lordship.
Sorry?
The petitioner and the girl are in the house of the parents, Your Lordship. They have no any obstruction or any objection, Your Lordship. That is why they have the consensual relationship between them, Your Lordship. Girl and the
What is
boy,
the age
Your
of the
Lordship.
girl?
My Lord.
Huh?
16 years and 21 years.
Heard Mr. So-and-so learned counsel appearing for the petitioner also heard the learned APP issue notice to the respondent number 2.
Malak 2 is not an 2 has to be there. Malak
Huh?
2
My Lord, I
not
have implemented you.
or subsequent,
My Lord.
By the issue notice to the respondent number 2
correct portion of it.
Right.
as per the prevalent notification. call for the case diary. When?
7th.
Eighth. 7 and 8 strike out. No further dates.
In the meantime, he may be allowed to go on. Well, he is a suffer. The girl is the baby is suffering from asthmatic troubles. They
The
cannot. Baby, your lordship.
the child which was born
Child,
out of the
my lord,
relationship.
okay.
We will pass an order directing the entire
And, due
district
to
medical
that-
team to be attending.
Due to lack of the parents, your lordship.
We will
they
direct the
cannot-
entire medical team of the district to be present in the house of the baby if required. But it does not make out a case of
Even
bail
then
when
they
a
have not-
15-year-old is involved. Sorry. Let the CD come. Let us see what statement she has made. Yes. 50. Yes, sir.
FR at page 21, my lord,
vernacular
May I read, my lord?
সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই লগতে আৰু 12জন ক্ৰমে হাবিলালি 1 আৰু 2 নম্বৰ পদকীয়াৰ পৰা ধৰিয়া খাইটি চৰত প্ৰায় 150 বিঘা মাটি মুঠ 13 লাখ টকাত দখল স্বত্ব কিনিল। উক্ত টকা মাটিৰ বাবদ পদকীয়াগণক আমি আদায় দিয়াৰ পিছত লিখিত কাগজ বিচৰত পদকীয়াগণে আজিকালি দিম বুলি কৈ 5-6 বছৰ ধৰি ঘূৰাই আছে। যোৱা ইংৰাজী 20 নৱেম্বৰ 2025 তাৰিখ নিম্নলিখিত পদকীয়াগণৰ লগত আৰু 20-30 জনীয়া ডকাইত দল হাতত দা লাঠি জোং আদি লৈ সুসজ্জিতভাৱে আহি উক্ত মাটিত থকা প্ৰায় 50 বিঘা মাটিৰ মাকৈ খেতি 4 নম্বৰ পদকীয়া ট্ৰেক্টৰেৰে ভাঙি তছনছ কৰি লগে লগে উক্ত মাটি সৰিয়হৰ বীজ সিঁচি দিয়ে। উক্ত কাৰ্যত মই তথা বাকী থকা 4-5 জনে বাধা দিবলৈ যোৱাত পদকীয়াগণে বাঁহৰ লাঠিৰে মোক তথা মোৰ লগত থকা কেইজনক কোবাবলৈ আৰম্ভ কৰে। উপায়বিহীন হৈ আমি ঘটনাস্থলীৰ পৰা প্ৰাণ লৈ কোনোমতে পলায়ন কৰোঁ। মোৰ লগত থকা হাৱা খাতনক পদকীয়াগণে কিল ভুকুৱা লাঠি আদি মাৰি মাৰপিট কৰি শৰীৰৰ বিভিন্ন অংগৰ ভিতৰি গুৰুতৰ জখম কৰে। লগতে শৰীৰত পিন্ধি থকা কাপোৰ কানি টানি ছিঙি পেলাই চুলিত ধৰি মাটিত বগৰাই চুচুৰালৈ ফুৰাই নাৰী শালীনতা নষ্ট কৰে। উল্লেখ থাকে যে প্ৰকৃততে পদকীয়াগণ ভূ মাফিয়া তথা গুণ্ডাৰাজ চলাই উক্ত গাঁৱৰ শ বিঘা মাটি বেদখল কৰি
Yes, we have seen.
Lordship, he is not named, FR name.
Hmm.
In between, two parties, this dispute is there regarding land grabbing. He is the of political supporter. Kindly have a last line. 2 নম্বৰৰ পদকীয়াজন যুৱ কংগ্ৰেছ দলৰ জিলা সভাপতি হোৱা হেতুকে উক্ত চৰত দাদাগিৰি কৰি গুণ্ডাৰা চলাই থাকে। The petitioner before a lordship is a private school teacher and supporter of this person. 2 নম্বৰৰ পদকীয়াজন যুৱ so under suspicion.
You are not named here.
No, my lord. And interestingly, in this case, out of the others, 2 sections are non-bailable. One is 318(4) and another is 76 BNS. 76 there is 354 B of IPC and 418 is 420. This is a punishment is extendable 7 years. That lordship may fine from forwarding report.
When were you arrested?
Yes, paragraph 6 we have stated, lordship. Paragraph 6. Paragraph 6, my lord.
For a date, I will go to the paragraph 6. What is the date on which you were arrested?
Sorry, my lord.
What did you hear?
Sorry, my lord. 9/12, my lord.
9/12.
12, yes, my lord. But I am referring to forwarding report, lordship. Kindly have a look, my lord. Page 29 onwards. Page 30 is the relevant. Here is mentioned note, lordship. There is a IO note. Notice 353 BNSS 2023 could not be served because there is every possibility that the arrested accused person will not comply with the condition of the notice. In this presumption, he is forwarded. However, it is mandated that extendable 7 years punishment, notice 41 and 41A CRPC should be served. In this case, that is not observed. So this arrest is illegal. So we are praying before this honorable court that maybe he may be allowed to go on bail. There is a judgment, Honorable Supreme Court in this regard held that. In Satendra Kumar until judgment, lordship, just I am referring, Honorable Court, permit me. Lordship, here is Honorable Court held that the court will have to satisfy themselves on the compliance of section 41 and 41A of the code, that is, well, CRPC. Any non-compliance would entitle the accused for grant of bail. From my lord, a forwarding report itself is stating that I was aware that 353, that 353 lordship is BNSS, earlier it was only 41A. He is aware that this notice ought to have been served, but it is not served. So my lord, it is ultimately it is illegal arrest, lordship.
Show me the judgment. Yes, APP.
My lord, yes, this has to be served, but reasons has been mentioned, my lord, and the details may be revealed from.
Which paragraph,
Lord,
did you
my lord, page 136 of the judgment,
Hmm.
paragraph lordship 100.3. That is my lord, conclusion. 100.2, my lord, here is held that the investigating agencies and their officers are duty bound to comply with the mandate of section 41 and 41A of the code and the direction issued by this court in Ernest Kumar. Any dereliction on their part has to be brought to the notice of the higher authorities by the court, followed by appropriate action.
Yes. Yes, Mr. Parashar.
But may kindly come to the section, my lord, BNSS.
Hmm.
BNSS. BNSS 35.
35 is the my lord, 41 only, CRPC.
Earlier 41, my lord. 35, not 3.
Hmm.
The police officer shall, in all cases where the arrest of the person is not required, under the subject 1, issue notice directing the person against whom a reasonable complaint has been made, a credible information has been received, or a reasonable suspicion exists that he has committed the cognizable offense to appear before him, or at such other place as may be specified in the notice. Now, yes, as per the judgment, my lord, yes, has to be given, my lord. But my lord, reasons has been given, but details may be in the case diary, my lord. Otherwise, my lord, that person in the grounds of arrest, page 29, grounds of arrest, during investigation, it is found that arrested accused person involved in selling government land, Tozi land, to the common people at Shore area. So he is doing this business, my lord.
That is where the ground mentioned, but actually, my lord, dispute in between my lord, FIR accused number 1 and 2. 1 and 2 are my son and father. In between two parties, and there was a political involvement also there, lordship.
He is,
And
that will come later on, my lord.
And my lord, admittedly,
Details in the-
petitioner.
Mr. Swansur and counsel paying for the petition also heard Mr. KK Parashar on APP paying the matter. Application paying for bail under section 483 of the BNSS 2023 in connection with Mongoldoy PS case number so-and-so corresponding to GR case number 843 of 2025. The petitioner has been taken into custody on 7/12, you said. When was he arrested?
9/12.
On 9/12/2025. Although he is not a named person in the FIR, the Honorable Counsel for the petitioner has submitted that the petitioner is a teacher and the FIR is a outcome of some political vendetta. Stop call for the case diary. List again on
6 if they do.
6th. 6 more than above.
Plus 7, 7.
7, 8 already full, my lord. There.
9 is full. Either 5th or 19th. 5th of January.
May
2022.
pray for interim lordship.
Interim bail from custody
Yes, my lord.
in a matter like this where outraging modesty ye, wo,
First day, my lord.
and sale of government land.
But he is
Let it come if you are not involved. Rest assured this court is there. Unless we find your custody necessary. How much time we gave you? Around 12 minutes. We were trying to go through everything to find out a way. We don't want custody. Let us be clear.
my lord, my lord,
Bail, not jail is the rule.
lordship.
Very first day, my lord, reopening.
This is 51.
Obliged. May I please, Your Lordship?
Yes, sir.
Lordship, FIR, Your Lordship will get it at page 24. The article, Your Lordship. By 6 individuals, Your Lordship. And it says, সন্মানপূৰ্বক বিনীত নিবেদন এই যে আমি নলবাৰী জিলাৰ স্থায়ী বাসিন্দা হওঁ আজি প্ৰায় 1-2 বছৰমান আগতে নলপুৰ টাউনৰ শান্তিপুৰত নৰ্থ ইষ্ট কাউন্সিল অফ এলাইড হেল্থ সায়েন্স নামৰ ইনষ্টিটিউটখনত শিক্ষা গ্ৰহণ কৰি আছিলোঁ আমি কিছুমানে শিক্ষা গ্ৰহণ কৰি আছোঁ আৰু কিছুমান লোকে শিক্ষা গ্ৰহণ কৰাৰ পিছত গকুল শৰ্মা পৰেশ বৰ্মনে সেকেন্ড ওয়ান ইজ মি ইয়াৰ্স টিম ভাগৱতী আমাক এখন প্ৰমাণপত্ৰ কিছুমান লোকে বিভিন্ন হস্পিটেলত আবেদন কৰাত উক্ত হোৱা বুলি জনায় আমাৰ প্ৰতিজনৰে প্ৰতি বছৰে amount has been mentioned আৰু কোনো ধৰণৰ প্ৰমাণপত্ৰ ইয়াৰ ফলত বিভিন্ন মানসিক ক্ষতিগ্ৰস্ত হৈছে he was arrested on 4/12/2025 your lordship 2 days police custody was granted your lordship thereafter he is in jail custody everything has been seized all our documentary evidence your lordship and main accused has not been arrested and your lordship may kindly come to page 38 in fact I am also a victim your lordship I have paid money to your lordship this northeast your lordship will kindly see this is they have granted me affiliation your lordship on the basis of these affiliations I your lordship started this operating this particular your lordship institute in Samata your lordship and on the basis of that I have also paid them money your lordship and ultimately they were not arrested your lordship the entire your lordship allegation your lordship police sought to fasten on me and your lordship will kindly see the certificate that is this is on merit your lordship on technical ground also I will make a prayer your lordship page 37 your lordship this is by them your lordship my signature is also not there on the basis of this your lordship they issued the certificate I only run the center at Samata your lordship this certificate is issued by them it is this is to a Paresh Burman so and so authorized referral center your lordship I paid them money your lordship on the basis of that they grant me affiliation and ultimately this has happened and in fact your lordship in 2024 your lordship I have given up your lordship will kindly see the affiliation also only for 1 year now your lordship already behind bar everything has been seized your lordship my center has been sealed your lordship that is also there your lordship and apart from that this your lordship this present case your lordship the conviction up to your lordship 7 years your lordship now if your lordship sees the forwarding report your lordship at page 26 why they have your lordship not complied with the section 35(3) of BNS that has not been your lordship mentioned even by the learned magistrate who has given custody your lordship he has also not the learned trial court also your lordship has not inquired why section 35(3) provision was not followed your lordship may kindly come to page 26 your lordship this is the your lordship forwarding report nowhere mentioned why 35(3) your lordship has
If
not been
2024 the certificate had expired
lordship
why was it functioning in December 2025
where your lordship
why were you why was this institute issuing certificates in the year 2025 when the registration was already over
lordship
the affiliation was over in 2024
yes your lordship which certificate your lordship
the ones which were found to be fake
lordship
this must have been issued this year
lordship and this certificate
so these certificates were issued
lordship
after the affiliation was over
no your lordship 2025 or 20 we have applied a separately your lordship not yet issued your lordship the your lordship will kindly see
no the persons who made the allegations
lordship
they were issued certificates which were found which are alleged to be fake now the affiliation of the institute was over in the year 2024
so far as
why
my-
issue certificates
no,
in 25
that is by this Gokul Burman your lordship
you are not from the same institute
no your lordship I was given affiliation in respect of only one center that is at Samata your lordship may kindly see the FIR again your lordship this was your lordship 1-2 years ago, we have got admitted in institute, namely Northeast Council of Allied Health Science Medical situated at Santipur, Nalbari, Your Lordship. This is not mine. I have taken affiliation from them, Your Lordship.
So you are affiliated to Northeast
Yes, Your Lordship.
Council of Allied Health Science. Yes, sir.
Lordship. And Your Lordship will kindly see 35-3 mandatory, Your Lordship. Your Lordship has already gone through, Your Lordship.
That we will decide in some matter where we do not find any other ground.
No,
Here we
Lordship.
find a ground where
Lordship.
you are one of the persons under this.
And secondly, Your Lordship,
Yes,
everything
sir,
has
2
been
days police
seized.
custody.
Matlab, ground of arrest page 26. Three, recovery of seizure and incriminating documents,
Page 26.
26.
Ah.
Ground of arrest, point number 3, recovery of seizure and incriminating documents, fake and false certificate, so seal issue has been seized, in indicating involvement of the accused. Now, possibility of destruction of evidence if left large, there is strong likelihood that the accused could destroy that.
You seal the premises.
Already sealed and seized.
Premises is sealed. So this four, not on the ground of arrest, what we are trying to see is whether you need the continued judicial, you need him to be behind bars. 2 days here, he was arrested on
4, Your Lordship. 4/12.
4/12. 2 days police.
Custody is over, Your Lord.
Thereafter another approximately 10 days to collect whatever they had to. Huh?
Objection is there, matlab, this type of person is.
We'll consider it in the case of Mr. Sharma. Who is the Mr. Sharma? Gokul Sharma,
Gokul Sharma.
Nasim Bhagawati. Or you want to have the CD,
Yes.
what has been collected?
Because page 27, this is clearly mentioned, page 27, to ascertain the role of each accused clearly, police custody is needed.
That police
Already
custody is
already
given.
there, already there, matlab. So, to know his role, only matlab, CD is required.
When you have the CD on the 5th, you kindly have the specific requirement of him being kept behind bars, the reason why he should continue behind bars.
Well,
The CD will contain a lot of things, lot of statements of the persons who were taking the classes. At this stage, why the continued custody? Documentary evidence, nothing else.
And everything has been seized, Your Lordship. And Your Lordship will kindly see the 35-3 is mandatory, Your Lordship. Your Lordship has seen Ernest Kumar as well as this until, Your Lordship. What until has says, Your Lordship, that it's bound to follow it, Your Lordship, there. Even the learned trial court, Your Lordship, magistrate, Your Lordship.
Did I read in cases where the arrest is not necessary, that has to come?
No, Your Lordship.
Here
will
the
write-
immediate arrest was
No,
necessary.
Your Lordship will kindly see, they have interpreted, this has been interpreted in series of judgments. Long line of judgment, Your Lordship. Your Lordship has seen.
it has to be given, but if not given, reasons.
Yes, Your
Reasons
Lordship.
has to be.
That is not there.
That reason is there.
That reason is not there, Your Lordship, why it is not given. And Your Lordship, it is incumbent upon the learned trial court also to look into why this has not been followed. That has been what has been in until it has been stated, Your Lordship. And there's one more judgment, Your Lordship, that is Muhammad Asfaq Alam. It also again says that for violation, disciplinary action should be initiated. So far as 35-3. It's a, Your Lordship, procedure.
Let us just have a report as to whether your all that was required to be collected from you has been collected.
Lordship.
If it has been collected, custody may not be required.
Lordship. I leave it to Your Lordship.
We'll keep it on the 5th,
Lordship.
on the first day. If we find that it has all been, Mr. S. Bothago, learned counsel paying for the petition, also heard the learned APP. 483 bill petition arising out of Nalbari PS case number so and so. Learned counsel for the petition has submitted that the petitioner was taken into custody on
4/12, Your Lord.
4/12 and thereafter remanded to 2 days police custody. And thereafter has been in judicial custody. He has submitted that all the evidence required to be collected are either in the form of documentary, in the form of documents, and the grounds of arrest to itself show that the recovery and seizure of incriminating documents have already been made. Stop. Yes, further submitted that the premises are under
Sealed, Your Lordship.
have been sealed by the investigating authority, and there is no chance of hampering or tampering of the evidence. Full stop. Granted, APP has sought for a short time to call for the details of the seizure, etc. made till now. Full stop. Call for the case diary list again on 5th of January 2026.
Obliged, Your Lordship.
Oh, you also write down. It has been submitted. That will be on the top, huh? With the other submissions. It has also been submitted that the petitioner was operating an affiliated institution under the organization which issued the fake certificates.
Deeply obliged.
If I may crave your lordship's indulgence for one mention, lordship. I just came to know that item number 19 has been mentioned. I am the amicus curiae in that matter, but I was not informed about the adjournment. Matter has been fixed on 30th of January. Lordship, I might not be available on 30th, so if it could be any date, maybe 29, 28, any date.
Adjourn.
Hmm. Will you be here on the 2nd?
Yes, Lordship.
2nd of February? Make it 2nd of February. Item 19. You give the date as 2nd of February. वहाँ पे लिख देना the learned regulate council. On that order, I had given a particular date. Na? Below that, right? Later, Dr. P. Agarwal appears and submits that she was not informed regarding the request for adjournment and that she would not be in a position to appear on 30th of January. Full stop. Accordingly, list this case on the 2nd of February. Oh, yes.
May it please your lordship. But here, Malad, that they have withdrawn it, Malad, and annexed the Malad, other case which is Malad, the petitioner is involved, Malad, alleged to be involved, Malad. Now, Malad, here, Malad, the petitioner is the owner of the cattle's, Malad. And item number 29 is the driver and the handyman. Malad, on that day, Malad, lordship was pleased to call for the case diary fixing a short date.
Is the case diary
29.
there?
29, sorry, Malad, CD not.
Malad, what I am praying, Malad, at this stage, Malad, 29, Malad, can it be after the vacation? And Malad, here, lordship may kindly grant me interim, Malad. I will produce all the documents. I have annexed the receipts, Malad, the cattle's receipt, Malad.
What, 2 days prior to the incident?
No, my lord. Lordship may kindly, to be, my lord, frank enough,
When was the
cattle
incident?
business.
When was the incident? 25/11.
25/11.
And the receipt is of 23/11. See, I said 2 days before.
My lord, yes, my lord. My lord, the lordship may kindly see, my lord. I deal in cattle business, my lord. It's a family. There are other cases. I was granted, my lord, interim pre-arrest bail, my lord. And my lord,
You were granted interim.
no, not in this case, my lord. Other case, my lord. But nowadays there is, my lord, necessary to we have to mention other cases.
Yes.
That order we have annexed, my lord.
Where is it?
Page 34 months of it. Page 34, my lord. So, my lord, at this stage, my lord, if my lord, let me produce that, they will verify, my lord, the investigating officer, my lord. And my lord, if my lord, they may verify those, my lord, receipts, my lord, whether they are genuine receipts or fake these receipts. And my lord, my statement will also be recorded, my lord.
We'll give him an interim protection. Come back with the CD with the number of cases that he has against him. The number of cattle he deals in in the other case at page 36.
Page 6.
The FIR is of 24/11. This FIR is of 25/11. Cattle bought on 23rd of November. 17 here. We'll give you an interim, go and produce the
We'll produce, my lord.
documents, have the CD, we'll consider, yes.
Item 29, my lord, let the case diary come. 29, they are driver, handyman, my lord, they are inside.
We'll fix it on the same day.
Same date, same day.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP. The petitioner apprehends arrest in connection with FIR lodged on 25/11/2025, which has culminated in North Guwahati PS case number 108 of 2025 under section so-and-so. First of the petitioner submits that he was the owner of the cattle which has been seized, and that he has documents to show that these cattle had been obtained lawfully by him. Full stop. He has also, the learned counsel for the petitioner has referred to the different receipts annexed with the bail petition. Full stop. The learned counsel further submits that in connection with another matter where an FIR had been lodged on 24/11/2025, the petitioner has been granted the privilege of pre-arrest bail when 15 numbers of cattle were found or were seized by the investigating authority in that case. Full stop. Call for the case diary list on 19. Huh? 5th or 19th is the only.
Yes.
8 তারিখ মানে বি এটা আছে
8 তারিখ 8 7 8
19
List on the 19th of January 2026. Full stop. In the meantime, it is directed that the petitioner shall appear before the investigating officer in connection with the North Guwahati PS case number
108
108 of 2025 within a period of 7 days from today. Full stop. It is provided that in the event of the arrest of the petitioner, he should be released on bail, subject to furnishing a bond of rupees 50,000 with one surety of the like amount. Stop. Further orders would be considered on receipt of the case diary. Item number 20.
29 also.
29, case diary has not been received. Item 29, take down. Case diary has not been received. List the matter again on 19th of January 2026 along with AB number 2961 of 2025.
I'm obliged, madam.
52. 52, my lord, there is instruction is required, my lord, whether any affair was not lodged or not, my lord. After some time, my lord, we have not yet received, my lord.
After some time.
Sometime we have called, my lord.
Because I don't think there was any FIR. He was saying that there is no FIR, but yet the police are searching for him. If there is no FIR, we can close it, giving you the liberty to come back as and when an FIR is lodged.
Clear as well, my lord. Lord, you'll find the FIR in page number 9. Basic allegation is that lady, my lord, he has uploaded a status with a letter maligning all the complainants, that lady and the minister, my lord. The status, it uploaded some leaflets, my lord. And my lord, thereafter, my lord, thereafter, Lord, will turn to page number 13 onwards, 13, 14, and 15. Notices were issued to him when 35(3), and she appeared. And Lord, will come to the last page, my lord, the original one, my lord, page 16A. And the mobile use, my lord, that has also been seized. He is cooperating with the investigation. 3 times he physically appeared before the IO, and the mobile has been seized, my lord. Investigation is going on, my lord. She is cooperating, my lord, and she will cooperate.
That Facebook account is
Not Facebook account, my lord. That
What
is
account?
WhatsApp status.
WhatsApp status.
Status is that goes out after 24 hours, my lord. He had uploaded that, and the mobile had been seized. He appeared for 3 occasions. Mobile seized, my lord. She is cooperating, my lord.
Heard. Mr. S. Bora, learned counsel appearing for the petitioner, also heard. The learned APP. The This application under 482 of the BNSS 2023 has been filed, praying for the privilege of pre-arrest bail in connection with Pasala PS case number 99 of 2025 under section so page 2, huh? The Illinois Counsel for the petitioner has submitted that as per the FIR, the petitioner had uploaded a WhatsApp status involving some allegations with regard to some ladies some ladies by using derogatory language. Full stop. The petitioner thereafter received notice as per section 35(3) of the BNSS, and she had appeared accordingly, and on her appearance, the mobile phone has been seized. Full stop. The petition, the Illinois Counsel for the petitioner submitted that she is cooperating with the investigation being carried out, and there is no apprehension that she might hamper or tamper with the investigation since the mobile has already been seized. Full stop. The learned APP objects to the prayer for pre-arrest bail. Full stop. We have gone through the contents and heard the learned counsel for the parties. In the facts and circumstances, we deem it fit to grant the privilege of pre-arrest bail to the petitioner in connection with Patsala PS case number 99 of 2025. Full stop. Accordingly, it is provided that in the event of her arrest, the petitioner shall be released. Make it 10,000, one surety of the like amount. Cooperate with the she shall cooperate with the investigation. Petitioner shall not commit any other. We'll put something. Social media is becoming dangerous.
Dangerous, man. Now she's getting the punishment.
She has given up.
No, she will give up now that she has learned a lesson, man.
The little one, what do you call it? Keypad mobile is the best.
Keypad mobile.
Apparently. Yes.
My lord, FIR is at page number 11.
11.
Typo. Not FIR named accused person. I received a phone call over my mobile number for Basishta Chalali police, wherein it has directed me to appear before the in connection with this case. My humble submission, my lord, and kindly peruse Annexure B, page number 19, my lord. My wife is suffering from cancer at stage 2, and regular chemotherapy is required to be done at every week, my lord. So, my lord, I'm ready to appear, but at this stage I may be protected, because if I have apprehension that if I am apprehended, my lord, it will go suffer. So my wife will suffer, my lord. So at this
So,
stage,
Parashar, we'll make an, yes, you are there. Yes, you are appearing. That's the APP, huh?
Yes.
Can you just find out one thing, an unusual request, of course. Can you find out whether any arrests have been made of the persons named in the FIR?
I have inquired, my lord. All of them have arrested, my lord.
All of them have been arrested.
Inquired. I'm no way connected, but despite I do not know why police are calling me, I will visit tomorrow, my lord. Today, my wife will be discharged from the cancer institute. She is admitted now also, my lord. I am only the attendant, and I have only one minor son, my lord. So every week chemotherapy is required, and sometimes twice also, based on the condition of my wife. So I will cooperate with the investigation, my lord. So kindly at this stage, I may be protected.
We'll call for the CD, we'll give him the interim. Huh? This is a prayer for pre-arrest bail. In connection with Vishwanath Sariali PS case number 213 of 2025. The Ms. So-and-so Learned Counsel appearing for the petitioner has submitted that based on the FIR dated 10/12/2025, the petitioner has received a phone call from the police authorities requiring him to attend, with regard to the investigation, full stop. The learned counsel for the petitioner submitted that the FIR named accused have already been arrested in connection with a complaint that they were extorting rupees 200 from each of the trucks passing through Bishwanath town. Full stop. The learned counsel for the petitioner has submitted that the wife of the petitioner is undergoing treatment. Undergoing chemotherapy treatment and requires the constant presence of the petitioner during the treatment, full stop. Petitioner is also ready to appear before the police authorities within 3 days to participate in the investigation as and when necessary, full stop. Call for the case diary based on 27th of January 2026. 27th of January 2026. The petitioner is directed to appear before the the investigating officer in connection with the case with Bishwanath Sariali PS case number 213 of 2025 within a period of 3 days from today. It is further provided that in the case of the arrest of the petitioner, he shall be released on bail of rupees 10,000 with one surety of the like amount, subject to the satisfaction of the investigating officer. The petitioner shall further provide all cooperation during the investigation and shall not leave the jurisdiction of the investigating officer without prior written permission. Bail to disu tar agote in the meantime likh in the meantime interim disu dispose na interim koi milai dibo. Yes sir.
Lordship, in this case, Your Lordship, the TCR would be necessary, Your Lordship. I think the matter, Lordship, the 161 statements as well as the other documents are not available on record.
The matter about
My lord, this is quashing of the FIR and the charge sheet, my lord.
why questioning of the
My
FIR?
lord, this is
What is wrong?
This is regarding, my lord, sale and purchase of, my lord, PP kit, my lord, during the COVID pandemic. Now, my lord, when they place the order for, my lord, supply of the PP kit, my lord. So we have supplied according to their, my lord, order. But they could not provide a vehicle, so we could not supply all the materials. Between, my lord, the government of Assam has cancelled all the order, my lord. Now, we are the my lord, supplier, my lord, they purchased from me, from our farm. So they could not, my lord, collect the PP kit, my lord. And in between, my lord, the government of Assam, my lord, cancelled their order, my lord. So now they are saying to refund the money. Now, in the invoice, my lord, it is very clear that since it at that time, my lord, that was the pandemic period, my lord, everywhere, my lord, emergency was there, and this PP kit, my lord, has to be collected by payment of 100% of the cash, well, of the cost. Now, we are collecting, my lord, PP kit from the manufacturers, my lord, various manufacturers. We are not the, my lord, manufacturer. We are just supply. So they, my lord, they lost this FIR, my lord, 421 and 406, my lord.
So you
This is
have
a commercial suit, my lord.
Huh?
This is purely a commercial transaction, my lord. And already they have filed a suit.
Yes, sir.
Perhaps they have filed a commercial suit, but Lordship, if Lordship produces the FIR.
Who has?
No, I mean, we have filed a commercial suit, but there is no bar that a commercial suit and a criminal case cannot run
Yes.
simultaneously.
Where is the cheating? Where is the cheating part on it?
Lordship, if Lordship produces the FIR, Lordship, at page.
So was that it requires a police investigation, we will not interfere. As simple as that.
Lordship, the quality of the PPE kits which they supplied, Your Lordship, that was not up to the standards.
Cannot be investigated by the police, can it be? Yes.
Now, my lord, their allegation is, my lord, the PP kit supplied by us. My lord, it is not up to the mark as, my lord, recommended by the DRDO and CITRA.
Lordship, in that case, if I may pray for passover of this matter, Your Lordship. My senior, Mr. A.K. Priya, will argue the matter, Your Lordship.
We
Lord-
need to,
Lordship,
we just need to know whether your allegations that you have raised, whether they require a police investigation or not. If it requires an investigation, we reject this. If it does not require a police investigation, we will consider his prayer, then he has to convince us to quash it.
My humble submission is that, Lordship, he's already on interim, Your Lordship. They have an interim stay in this. The
Ah.
proceedings are stayed. Lordship may call for the 161 statements regarding this case because charge sheet has already been filed. Thereafter, Lordship can fix a date after vacation. On that day, it can be disposed of. It's not fair,
Should
Lordship.
we keep it part so we can hear you again? You heard Mr. K. Sinha, learned counsel appearing for the petitioner, also heard Mr. Swain. The learned counsel for the respondent has submitted that the, no, you are?
I'm appearing for Mr. A.K. Priya. My name is Anar Sharma.
You're appearing for the respondent number what? Two.
Six.
Who appears for the respondent number 2 has submitted that the trial court, a scanned copy of the trial court records may be required for adjudication of the matter. So
My lord, trial
accordingly,
court record is already there. Only this, I think 161 statement is
Statements are
not
not
there.
there, Lordship.
call for the updated trial court records. Some TCR to ascend. That TCR can give you. When was it called for? Hmm? Hmm? This came on 8/2/2024. When was the stay granted?
Stay is granted.
Hmm. Two, 4. Where will that come from, your statements that you are saying? Which statements do you want to refer to? Huh?
Lordship, the 161 statements of the accused persons
Ah.
as well as the informant, Lordship. But TCR, it is mentioned that perhaps the charge sheet, Lordship.
Hmm?
Charge sheet is mentioned, Your Lordship. At page 58. Recorded statement of the complicit and witness under section 161 CRPC seized documents related to the case. So and so, Caesar list enclosed with hearing below. Interrogate accused persons, namely Saurav Kumar, Sharma, Rachna, and Rachna Puri.
The
and
case
request the
records
statement.
received from the case records received from the office, from the CGM Kamrup Metro Guwahati does not contain these statements made by the made under 161 CRPC. Full stop. Call for the complete records of the call for the complete records along with statements recorded under 161 CRPC. For adjudication of the case. When do you want it? List again. 21st of January. 27th. 27th of January. List again on 27th January.
Well, interim may be continued.
The interim interim order passed earlier to continue.
Wait, Lordship, my lord, this is a previous petition under section 482 of the CRPC, my lord. For quashing of the proceedings. Here, my lord, you will also kindly see the girl admits, girl is, my lord, elder to me by 1 month, 25 days. And she falls in love with me, with me. Both are, in a sense, minor by few months. And she claims to be, you'll also come to FIR first. Page 11, Annexure A. Married, my lord.
Yes.
Most suspectly, and the incident is of 17/7/2022, my lord. You'll also can note the date, and the FIR is of 1/8/2022. After about 13, 14, 15 days. Most respectfully state that I, Muhammad Abdul Aziz, a permanent resident of Dalbathar, under the Batadarba police station, on 17/7/2022 at around 2 a.m. at night, taking away my absence at home, the above named accused number 1 along with one unknown person have kidnapped my daughter Musammat Marjina Begum, 17 months. In the morning, not finding my daughter in her room, and on inquiry, I came to know that my daughter eloped with the above named accused number 1. Then my nephew Ziaur Islam went to the house of the accused persons and discussed the matter with the accused number 3. Since my daughter is minor, therefore, we decided to once she turns 18, we will get them married socially and even executed an agreement in the court on it. Sir, the incident is not ended yet. Again, the accused number 1, with the help of the account 2 and 3 and 4, taken away my daughter, and due to fear, they confined secretly my daughter in the house of the grandmother of the accused number 1. Thereafter, the accused number 1 had been avoided to meet my daughter, and on one after another pretext for which my daughter left the house of the grandmother of the accused number 1 for her house. Then the above named accused have abused my daughter with filthy language, and the accused number 2 and 3 have charged with thou. After that, out of fear, my daughter locked herself inside the house and informed me about the incident over phone. Sir, we tried to sit together and settle the matter, but failed to do so. Since we are trying to settle the matter amicably, for which caused delay in lodging the FIR. Therefore, you are requested to take necessary action. This is the FIR matter. Now you will also finally come to 164 statement of the girl. Annexure B, page 15. On oath, it is true that the above mentions my name, age and address, since from 2 years.
Who appears for the respondent number 2?
Some name are shown, A. Begum and others. And Begum and others.
Can we wait for some time without hearing her, without hearing the respondent number 2? We will not be able to decide it as such. Because the girl's statement is there regarding
But
2 of the fellows.
She doesn't say, Mother, it is not. Case is not registered under 376. Only kidnapping and confining.
Charge sheet has been submitted.
Yes.
Why do you say it should be quashed?
Well, because there is no ground. If your lordship, after reading, going through the 164 statement of the girl, in the meantime, let me just go through the statement.
I have read it. That is why I'm saying, which part you want to, which part you would like to? Yeah, this 161 statement that you are reading. Page 16.
Yes,
The names are there.
yes,
The names are there. Page 16, last
yes.
2 lines, the names are there. Even if we keep that out.
Yes. I mean, but I think exaggerated, my lord. That rape, allegation of rape and all
Uh-huh.
things are not there.
All this will come in during the trial. Why should we cost the charge sheet when we just want a law that this is why it should be cost. We will be with you.
Because, my lord, in the charge sheet,
Huh.
there is no allegation of rape or anything. But in the 164 statement, she said,
Hmm.
so. Well, I mean, brother and so forcefully raped me. He is not there. And 160 in the otherwise in the chief also, my lord, she doesn't say anything. And the case is not registered under rape charge.
Just for some time, let us put up a scroll
But-
if
but
the
I've got a case in division. So let it be after the view, then finally.
if
Uh,
anyways the proceeding has been staged. So
Yes, yes.
heard Mr. R.P. Sharma, learned senior counsel assisted by Mr. So-and-so. Also heard
And that's the.
and the counsel being learned APP. The and appears for the respondent number 2. Although some name shown.
The name is shown. Names are
Although
shown.
Mr. S. Gautam and Miss N. Begum have been shown to have entered appearance by filing wakalatnama full stop. Is this matter again on 30 January?
But
30
20 January, I will get some other date.
30 January 2026.
Good day, matter is there, my lord.
Huh?
On the day either I do matter.
On 30 January 2026. So
Alright,
in time order passed earlier shall continue.
Item 10.
In this case, Lordship, I have challenged the order dated 1/9/2025, which is in page number 39. In this, what happened, Lordship? FIR was lodged against the petitioners, and thereafter charge sheet was filed, and it held that this is only a road accident, Lordship, motor vehicle accident. Thereafter, trial was going on, including against the driver of the vehicle, and they filed an application, Lordship, for treating it as impleading the present petitioners also. That was rejected, and thereafter the learned court passed impugn order dated 30, Lordship, 1/9/2025. That is at page number 39. Annexure 7, Lordship. Accused Mofizul Ali is present. He is the driver of the vehicle, Lordship. Today, the date is fixed for necessary order as the PW1 Mohibul Haq and CW1 Siddiq Ali deposed before the court that the accused persons, namely Mofizul, Somidul, Samsul, Sohidur, Foizul, Mohibul, Rafiqul, and Nasser Ali, assaulted the deceased, namely Akkel Ali, Mominur Haq, and victim Siddiq Ali on the road, and the above named accused killed Akkel Ali on the spot, and due to the assault, the deceased Mominur died afterwards, and Siddiq Ali also sustained grievous injuries. I have gone through the Azahar lodged by the informant Mohibul Haq, wherein the allegation is that on 11/1/2018 at about 7 p.m. while his younger brother Mominur Haq, his uncle Siddiq and Akkel Ali were going towards their home on the motorcycle bearing registration number so-and-so, then at Dumraha Bridge, the accused, namely Mofizul, Samidul, Samsul, Sohidur, Foizul, Mohibul, Rafiqul, and Nasser Ali came from the opposite direction in a Bolero vehicle bearing registration number so-and-so, and they intentionally hit the motorcycle, due to which the victim fell down from the bike, and after that the accused persons got down from the Bolero vehicle and assaulted the victims, causing them serious injuries, and due to the injuries, Akel Ali died on the spot and the other two sustained severe injuries on different parts of their body. After the incident, they were taken to Dhubri Civil Hospital, but Mominur Haq died on the same night and Siddiq Ali was still under treatment at the time of lodging the Azahar. However, perusal of the charge sheet shows that the charge sheet has been submitted against the accused Mofizul Ali under section 279, 338 and 304A, Lordship. Now, considering the evidence of PW1 and CW1, I deem it proper to implead the accused, namely these persons where, Lordship, notice was given under section 319, Lordship. So let summon be issued upon the accused persons Mofizul so and so accordingly fixed 3/11/2025 for appearance, and while issuing notice, this order was kept in abeyance, Lordship. Stay was granted. Lordship. Lordship will kindly see the charge sheet. Page 20, Lordship. Page 22 is the relevant portion. During investigation, I visited the place of occurrence and interrogated the informant and independent witnesses and carried out investigation locally. On the basis of evidence and local investigation, one distressed vehicle was found and I seized both the distressed Bolero picked up bearing registration number so-and-so and motorcycle bearing number so-and-so and got the distressed vehicle inspected by the FBI, and thereafter both the vehicles were given on Jimma as per Jimmanama. The persons died in the accident, namely Akel Ali, Mominur Haq, and Baidul Hussain, were sent for post-mortem and post-mortem reports are enclosed herewith. In addition, I provided the 54 number certificate in respect of both died in the accident and for McLean. During investigation, the medical report of injured Siddiq Ali was collected. During investigation, the FIR named accused persons so-and-so all are residents of Roa Part 2 have not been found committed any offense in the incident and no offense has been established as mentioned in the FIR. On the other hand, during investigation, the offense established under section 279, 338, 304A IPC against the driver of the vehicle so-and-so, all resident of Chagolia Part 2, and he was arrested and released on bail. As the investigation was completed, the matter was discussed with Lordship CI and his advice was taken. Having taken his written opinion as supervisor and as per his direction, the matter instead of keeping pending and as the offense under section so-and-so has been established against accused Mofizul Ali, driver, I submit the charge sheet. On the other hand, I pray before the Honorable Court to discharge the persons who were not found involved with any offense, a copy of bail bond, 2 copies of post-mortem reports, medical report of the injured and seizure list are enclosed with the charge sheet. The
Yes, sir.
witnesses mentioned in column number 6 of the charge sheet will prove the case. So this is the charge sheet. In fact, Lordship, this is a road accident. 3 persons were riding a motorcycle. They collided with a Bolero pickup van and accordingly the Lordship accident took place. One petition was filed, that is Annexure 3, page 25. That is petition number 5333. Your Lordship will find in the TCR, maybe it is available, 25/2/2025, they filed this petition. Petition of the petitioner victim Siddiq Ali. He is the survivor.
Petition number?
25533, Lordship, 5333.
On?
25/2/2025. That I received the summon to witness and appear before the Honorable Court to adduce my statement that the present accused Mofizul Ali, son of Dildar Ali, is not the person they filed the FIR against. The informant had filed against Mofizul Ali, son of Nasir Ali. He is the owner of the vehicle, Lordship, and Mofizul Ali, the driver, is another person whose father's name is Dildar Ali. So there are 2 Mofizul Ali, Lordship. In view of this discrepancy, the case necessary to investigate further and clarify the identity of the actual accused. Therefore, it is prayed that your honor would graciously be pleased to pass necessary order and dispense my witness today and thus oblige. This petition was already rejected by the trial court on 6/5/2025. Annexure 4 I have enclosed. Accused is absent with steps.
So
by
what happened is, although originally an FIR was filed saying what? The FIR,
saying
what
that
did it
there
say?
is an marpit, lordship, there is an
And they
attack.
expired.
by
Then
the-
the police comes up with a
It's a motor
report that
accident.
it was, there was a motor accident. The motor accident is not denied.
No, lordship.
They
They had
police
filed
says that,
MSCT case, lordship, and they had
the police say that, yes, we found the vehicles, persons have died. We do not find any evidence of the fire, scuffle or fight or anything.
there was no intentional
And
attack.
then
on
these two people, they come and make a statement before the court that yes, there was a fight and these
the
people were
circumstance
killed.
of the accident, lordships, that Siddiq Ali, he filed an application that was rejected. Thereafter, court came to a decision that
On the basis of the statements recorded before it.
by the CW lordship.
What
Lordship,
is
can
wrong
we
in
see
that?
this order dated?
What is wrong in that? If the
Lordship,
court
this is-
finds that there may be things which require investigation or which require trial, what is wrong?
Lordship, this is completely a motor vehicle accident. They had not denied that and they have already obtained award from the Motor Vehicle Claim Tribunal, lordship. That also I have
That is
enclosed.
a separate issue. The motor vehicle accident may be there. And the claim may be there, payment may be there. Between the cars striking each other and between the person reaching the hospital, things happen in between.
Their allegation that, lordship,
So
we
the truth or otherwise of the allegation is something that the trial has to go into or the investigation has to go into. We have to see whether it had the powers to issue you summons
Yes.
or whether it was correct in appreciating in the manner it was appreciated. Tell us about that. Don't tell us whether it was true or false.
may admit, I will satisfy your lordship in the hearing. If it comes for hearing, then I will satisfy your lordship.
Because straight cases, statements were made before the magistrate found that yes, this would require some investigation or trial. So please come. There is a summon for you to appear.
Lordship,
To appear, you convince the magistrate. Why the revision?
lordship, the harassment to the petitioners, they are not involved with
That
the
is because of
cases.
statements made.
Lordship, they,
Every accused who is at the end of the day acquitted has been harassed.
that is one thing, but here
harassment to
they
the-
want to give the color of a accident. as a-
Ah.
Lordship,
That is
intentionally
why we
done.
are also trying to look into the PM report. If the PM report does not give any indication of any striking, or if the accident, if the injuries sustained were purely of accidental nature of a road traffic accident,
That is,
you would have thought otherwise.
they have admitted that it is a pure
Moreover, my
accident.
lord, accused are, my lord, named in the FIR, my lord. It's specifically mentioned in the FIR, my lord.
Then we read 2 or 3 sentences saying that they had asked money for this and money for
And
that.
my lord, trial court has ample jurisdiction, my lord, ample power.
319, there are ample jurisdiction, that I agree, lordship, but
Hmm.
lordship, in this case.
Why should we interfere is what you have to tell us, madam. It may be a false case against you, we don't know, it may be a false evidence. But would it stop the court from taking up the matter in the manner it has been done? No.
Once their petition was rejected,
Ah,
lordship,
so-
that matter cannot be.
So their right is closed.
Lordship,
What about the jurisdiction of the court?
But lordship, it was already decided by earlier predecessor.
Why was it rejected?
That is annexure 4, lordship.
Why was it rejected through us?
57.
There must be some ground of rejection.
Accused is absent with.
Absent with steps, heard, so heard.
Both parties on petition number 533-33325 filed by the PW Siddiq Ali through the learned APP stating that accused Mofizul Ali so-and-so is not that person against whom he lodged the FIR and that he filed the Ejaher against the accused Mofizul Ali, son of Nasser Ali. I have gone through the case record which reveals that though the case was registered so-and-so under so-and-so against the accused persons, namely so-and-so, but after investigation, charge sheet was submitted against the accused Mofizul Ali of so-and-so.
No, there was a petition that please identify the actual person.
Lordship.
Have an investigation, identify the actual person. That has been rejected.
But
Whether the
to
That has got nothing to
trial
do
to
with
be
the,
started against that person, Lordship.
huh?
Not against.
You are
the
enjoying
judge.
you are enjoying a
Yes, Lordship, stay.
admit the criminal revision petition. Trial court records have been, scanned copy of the trial court records have been received. List again on 5th of February 2026.
Final hearing, Lordship.
Huh?
For final.
On 2026 for hearing. For hearing. Huh? Interim order to continue.
They already appeared, Lordship.
Will.
They already appeared.
Huh?
The private respondent already.
They appeared. Your
Obliged,
thank you.
Lordship.
May it please, your lordship.
Yes, sir.
One of the petitioner before your lordship. She's a my lord doctor by profession. She's an assistant professor under provision in the Indian Institute of Medical Science, Guwahati, of the pediatrics. Now, my lord, she has been a victim of sexual harassment in a place of work, my lord. And lordship will kindly come to that report at page number 56. And the operative portion is at page 60. It's a part of the findings of the ICC, the part 6 conclusion. The IC concludes that the aggrieved woman, Dr. Nisha Toteza, was subject to sexual harassment at workplace due to hostile work environment caused by respondent, that is Dr. Jayashankar Kaushik's act of omission commission and unwelcome behavior based on witness statements and documentary evidence which led to hostile work environment amounting to sexual harassment as per Sexual Harassment Act of 2013, that is clause so and Central Civil Service Rule so. Now, my lord, what this AIMS authority have done, my lord, they have rejected this complaint. Sorry, report of the ICC. I do not know under what authority they did it. The director, my lord. Director wants to protect this gentleman called Dr. Jayasankar Kaushik. Now, my lord, my husband, who was also on probation, my lord, he has already been terminated. Now, they are on the threshold of terminating my service also. Such vindictive action. Now, my lord, just to show how, my lord, they have acted and the judicial notice was taken note of by this honorable court. I'll come to the complaint little later, my lord. Please come to page number 28, my lord. This is an order passed by this honorable court in a writ proceeding where this observation was made, para 8, page 28. It's part of order dated 14th of February 25 in IA 414 of 25. Such action and conduct on the part of the executive director, All India Institute of Medical Science, Guwahati, in the backdrop of the litigation and order passed by this court, in the considered opinion of this court, is suggestive of malicious action. Therefore, subject to further deliberation and the response that may be made by respondents in the IA as an interim measure, it is provided that warning letter dated 3/2/25 shall remain suspended till the next date fixed. My lord, in that proceeding, my lord, while there was an order not to take any coercive measure, these warning letters were issued to me so that they can make out a case that I am not fit to be confirmed, my lord, because I am on probation. That is the plea, my lord. Now, my lord will kindly come to the complaint, which based on which, my lord, the alleged defamation cognizance was taken up by the trial court. My lord, is at page number 29. My lord, this is a complaint which I wrote to the PMO. And this is the basis of the, my lord, defamation case. Kindly see, my lord. This is to apprise you that I am a victim of workplace harassment by Dr. Jayaprakash Kaushik, additional professor pediatrics.
You are at page number?
At page 29, my lord. This is a complaint which the petitioner submitted before the PMO, my lord, against the management of All India Institute of Medical Science.
Page number 29 in my record is a
2 copy, my lord.
A notice under section 223 in CR case number 124 of 2024.
In that case, my lord, could it be page 28, my lord?
Page 28 is otherwise the order that you had just read out shall remain suspended. Warning shall remain suspended.
Or my lord, is it page 40, my lord?
Could be.
Eh?
Page 40 is, respected sir, this is to apprise you that I am the
Yes, yes,
victim.
yes.
Yes.
This is the, my lord, the defamation case has been premised on this. This is to apprise you that I am a victim of workplace harassment by Dr. Jaiprakash Kaushik, additional professor pediatrics. I had given my grievance in writing to Professor Ashok Puranik, that is the executive director, in August 2023. I was misdirected to the Internal Grievance Redressal Committee against the provisions of the Prevention of Sexual Harassment Act 2013. The report of the committee was never given to me despite multiple representations till I filed an RTI and received a copy in May 2024. Once the perpetrator was made aware of my complaint, I went through an extreme retaliation which took a significant toll on my mental and physical health. While there was no report or redressal or preventive measure for months given by IGRC, I filed a complaint for protection to the Internal Complaint Committee of the Institute along with a retaliatory mail with threats by the perpetrator. IC, after giving a comprehensive report, concluded that perpetrator had indeed committed workplace harassment as per provisions of the POSH Act of 2013 and should be treated as a misconduct. However, the institute's director set it aside on his own authority illegally and issued warning letter to the complainant instead of perpetrator without following the procedure. When I approached the institute's president, director again issued a warning letter for doing so. After having made multiple representation without any semblance of justice and having exhausted all channels of redressal, including that of the governing body, I am appealing to you for your interference. Now this is the Miller. There are several gross irregularities, including non-compliance to the POS rule, corruption, receiving illegal gratification by the executive director, canvassing in recruitment and non-compliance to seniority and selection rules according to the AIMS Act. My case brought up all these issues and hence I am being silenced by authorities. Please help. Now this paragraph has been construed to be defamatory and my lord, I understand. I do not know how far it is correct. I was told, my lord, the learned magistrate offered him a cup of tea before issuing the process. My lord, kindly come to the order now. Now the complaint is at, my lord, page 29. 29 to no. And in fact, page 40 is the annexure to the complaint. So this is the only element of defamation, my lord.
Page 20.
The complaint which has been filed against me, it starts at page 29, my lord. 32. The pagination to क्यों मिला है I total my lord, the court notice is at page 30, I suppose, my lord.
Your attendance is necessary for hearing on a point as to whether will take cognizance.
Now this is the complaint and page 40 which I read just now is the annexure, my lord. That is the alleged defamatory thing. And my lord will kindly come to the order which has been passed by the learned court below. Please come to page 83, my lord. Heard learned counsel for both the parties on the point of cognizance, peruse the complaint petition and written objection submitted by respective parties. Upon hearing and perusal, this court is satisfied that there are sufficient materials to proceed. In the instant case, accordingly, complainant is directed to remain present on the next date along with his witness for examination under section so and so. For examination of complainant under section so and so. Then, my lord, at page number 84 is the order for appearance to the petitioner. Whereas, upon perusing the complaint, commission has passed the following order to appear. This is by National Commission for Women, my lord.
Against my complaint.
Against on my complaint.
The director. Sanjay Mehta, sir. Sanjay Mehta, sir.
And my lord, I have annexed the order of the honorable court in the writ petition, my lord, whereby my writ petition was allowed.
Page 94.
Page 94, it starts, my lord. Anyway, my lord, these are to show, my lord, how vindictive the authority had been. And I may also inform your lordships one more aspect, my lord. Now the AIMS authority is contemplating to take action against one lady doctor who was a part of the ICC. Well, this gentleman, this present executive director, my lord, I think these are inhuman, my lord. Kindly see a lady who is a victim of sexual harassment. Now she has been again further subjected to harassment. Because she filed a complaint, my lord, he had the audacity dehouse the statute, that is 2013 Act, to reject that complaint and instead initiated action against me, which I own in the, my lord, in the writ court. Now, my lord, my humble submission is, my lord, Article 19(1)(g), 19(1)(a), my lord, it gives the people the right to know. My lord, is my utterances or my complaint to a higher authority contain any element of defamation, my lord? That means I cannot even state the facts. Supposing I perceive that a person is, indulging in corrupt practices. If I say so, will it amount to defamation, my lord? In that way, my lord, then Article 19(1)(a) will lose its relevance.
The grievance for health and family welfare. The grievance of the health and family welfare.
So, my lord, my humble submission is, this complaint could not have been taken cognizance of, my lord. It's an abuse of the process of authority, my lord. There is no element of defamation in this case. If I allege some acts of omission and commission on the part of somebody, if it is to be considered defamation, my lord, there will be no end to it. And Article 19(1)(a) will lose all its relevance. Yes, in a given case, while trying to uphold one's right to information, if one, my lord, exceeds that Lakshman Rekha, then it may amount to, defamation.
And after which we are filing the quotation. 10. The affidavit of positions.
Now, if your lordship would kindly come to page 108, my lord,
The affidavit of position.
of the affidavit in opposition filed by them. After the judgment rendered by Honorable Justice Medhi, my lord, in the writ petition, this is the response of the institute, my lord. Kindly see.
Page?
Page 108, Annexure 2 of the affidavit in opposition. It is submitted that has your lordship got it, Miller? It is submitted that WPC so-and-so was disposed of by the Honorable Guwahati High Court by its order dated so-and-so with direction that governing body of the AIMS Guwahati is to take a decision on the complaint of sexual harassment made by Dr. Nisa Toteza and report submitted by the Internal Complaint Committee of AIMS. Accordingly, governing body AIMS of Guwahati has held 3 extraordinary meetings on so-and-so to discuss and take decision on the matter pursuant to Honorable Guwahati High Court directive.
Who has written this?
This is by the, my lord, governing body of the
To whom?
AIMS to register Guwahati Judicial Guwahati High Court.
What business is that?
Accordingly, governing body of AIMS has held 3 extraordinary meetings on so-and-so to discuss and take decision on the matter pursuant to the Honorable Guwahati High Court directive. After proper deliberation, governing body has taken a final decision as follows. The complaint of sexual harassment against Jayasankar made by Dr. Nisha Toteza is not substantiated by available record evidence and the case stands closed forthwith. No further inquiry in the matter is warranted as per provisions laid down in para 12 of the DOPTO as reproduced, this so and so. Minutes of the meeting is enclosed herewith for a kind reference.
And that was, and this, after that, they terminated the, and this was the quotation.
It will do.
The order.
Now, if your lordships would kindly have a look at this order, my lord, which just now we have handed over. If your lordships would kindly come to page 3, the first subpara. The writ petition was disposed of by order dated 5/6/25 by interfering with the impugned communication dated so and so to be not sustainable in law as it was issued by an authority without jurisdiction. It was further observed that if governing body assumes the role of disciplinary authority, respondent 5 should not be made a part of the same and his place be taken by another officer of equivalent rank. However, pursuant to the said direction, governing body aims had taken the impugned decision dated 7/8/25, closing the complaint of the sexual harassment against respondent number 6, and had also issued notice of termination of service to the petitioner. Said notice has been issued by respondent number 5. The learned senior counsel submits that same is clearly in violation of the court direction at para 20 of the earlier order dated so and so. Learned senior counsel submits that the impugned action has been taken apparently in view of the complaint submitted by the petitioner against respondent number 5 and 6 before the Prime Minister's office on certain mismanagement of fund. He also submits that as per the experience certificate issued to the petitioner by the competent authority, our working has been found to be good and conduct and integrity were also found to be beyond any doubt. Not only this, senior counsel submits that as per OM dated, even in case of provisioner who is not making satisfactory progress, has to be informed his or her shortcoming well before expiry of the original provisionary period, and so that she can make special efforts for self-improvement. The same having not been followed, learned senior submits that the impugned notice of termination cannot be sustained. As a matter of fact, my lord, this order was stayed by this honorable court. Now kindly see, my lord, while passing the order dated 7/8/26, my lord, the same respondent number 5 was a party. Whereas this honorable court said he will not be a party to that. Para 20, my lord, of the order.
The petition, page 93. Page
Respondent number 5 should not be made a part of the same.
Yes. And now he is a party to that. While closing that petition, my lord, para 20. 20, huh?
Yes. So should be part of this.
Respondent number 5 should not be made a part of the same. That means by virtue of his office, my lord, he is an ex officio member of the governing
He
body.
should not be a part of
But
it.
he was now he's a party.
It was the same complaint.
And kindly see, my lord, as per the judgment of the Supreme Court in that case, this ICC report is to be taken as a inquiry report.
Yes.
And thereafter proceedings should start. Where is the question of not accepting that report, my lord? Just to show, my lord, how things are moving, my lord. And kindly see, my lord, what is the element of defamation in that complaint?
It's the same, same period.
Proceeding to the stay phase.
Stay.
My lord, the proceeding was stayed by this honorable court, but my humble submission is, my lord, it's a fit case, lordship will quash the proceeding, my lord. And I do not know how long I'll, my lord, be harassed. My husband has been terminated. I am fighting litigations after litigation. Your lordship looks at the attending facts and circumstances and the scathing observations of this honorable court in the earlier rounds of litigation. My lord, the malice is apparent on the face of the records, my lord. And just to harass me, my lord, now they have filed a criminal complaint.
Demo report.
May I please? Lordship, when I was.
No, before we go into all the details, there have been judicial orders passed for clients not to communicate with the registry of the court with regard to pending or disposed of cases, is it not?
Please.
Instructions were sent to the registry in pending cases. This court took a very strict view of the matter. Page 108, something that your affidavit shows
Lordship.
that your institute is writing to the registry of this court with regard to particular WPC numbers, saying what steps they have taken.
The court
Directed so?
The court had directed
To do what?
that the GB, that the court had directed that the GB is to take a decision and intimate, and therefore it was just the intimation.
Cannot
after-
be. Any communication with the registry by litigants,
Post the judgment of the court. This is
everything
post
done,
judgment.
everything done. There were no directions, there was no required to communicate.
I'll, I will.
So we are not taking any exception to it as of now, but kindly have your clients instructed that this is not an higher office for them. We deal with matters when the matter is pending before us, and we deal it through officers of the court. We don't need this kind of information being sent to our registry useless.
Conveyed.
Yes, now on the merits.
Now let's come on the merits. Chair, before I start, when I was hearing the learned senior counsel, I was wondering whether we are talking of WPC of this particular 5090 or we are talking of WPC 2316, which has been closed. Number two, there are certain false, fabricated, misconstrued allegations which have been given or facts brought. I will provide the correct fact. It has been repeatedly emphasized that the husband has left after he was terminated from service. I would like to emphasize that that is a false statement, and he has left after resigning from service because he had got better opportunities in Kerala. So that is number one. Number two is that this matter, which is being referred to 2316, has been closed by this honorable court. Learnatory, and this may be put on record, which is a defamatory that the learned.
Just 1 minute. Today it has come up on the hearing column, sir. That is what we were wondering. Today it has come up on the admission column. It has already been admitted on 30/10/2025. Being a motion day,
What will happen?
people waiting for other, since I think there is an interim. We'll have it on a day when we can actually go through all the material and find it out.
Yes.
Lordship, but a short date, Lordship, because this has been dragged on. The executive director has been repeatedly, this has been dragged on from June onwards.
First week of January, we are full. Second week of January is the Bihu part. Third week of January, we have already fixed around 17 cases on each day.
Lordship,
First
will it
week
be
of
on
February is the
22nd?
best. 2nd of February.
22nd January.
22nd January, we have already fixed 19 cases.
23rd,
Is Sri Panchami, we are shown red.
24th.
Saturday,
Let it be in the first week of February.
it can be 30th January, we have time. It can be 2nd of February, it can be 3rd of February, it can be 4th of February, it can be any day after that. 3rd of February is
I'll just.
PC এখন আহিছে নে? পঢ়া নাই।
LCR টো আহিছে নাই?
Mood case of.
Whether lower court record টো আহিছে নে?
It was not called for.
Oh.
Lordship, can we have it on 29th or 31st of January? Any date?
Saturday.
29th or 30th, we can have it.
Well,
Of course,
30th, I have some
30th.
difficulty.
We have
30th is
also.
difficult, so we'll have it.
We'll
on-
have it on second, Lordship.
Second is a Monday and third is a Tuesday. It is your choice. We'll have it on Monday, sir. Tuesday, 3rd of February. Yes.
Disposing a matter, the Monday is a motion day.
The additional affidavit filed by the respondent is on record. This matter was already admitted for hearing by order dated 30/10/2025.
It's not an additional affidavit, it is the affidavit in opposition.
They cut out the word additional, make it the affidavit filed by the respondent number 2 is on record. Matter was already admitted for hearing on 30/10/2025, yet it has come upon the admission column. With the consent of the learned counsel for the parties, list this matter on the 3rd of February
Yes, interim order. And interim.
for hearing.
Interim order.
The interim order passed earlier shall continue. Yes, we'll have it on the 3rd of February. Otherwise, we're at item number 10 is solicited. No matter. Bail hearing kita agora di দিব. Yes.
May I please,
তো খালি ক'বাত লিখি পেলাই দি দিয়ক bail hearing matters will be taken up. নহলে হা আজিতো হৈ গ'ল। চাওঁচোন। Yes.
Dear Lordship, the application is under section 578 of BNS. This is an absconder charge-sheeted case, Lordship. Out of 3 charge-sheeted accused, Lordship, 2 are already allowed on regular bail, and the present petitioner is declared absconder in the charge-sheet, Lordship. Now the case is registered as PRC case, and after checking the cognizance, Lordship, someone issued against the accused person, Lordship. It's the appearance stage, Lordship.
He apprehends?
Appearance stage, Lordship.
Appearance says yes.
Lordship, next date is, Lordship, 12/3/2026.
You want to appear and
Yes, Lordship.
contest.
Yes, Lordship.
You go and file an application there.
No, Lordship, there is a bar, Lordship, under section 232 of BNSS, Lordship. This is a case taking cognizance under section 302, 302, Lordship. This is a bar, Lordship. So if I am appeared, then, Lordship, learned court below, Lordship, send to judicial custody, Lordship. So, Lordship, I am bearing before your Lordship that direct the learned court below to
Enlarge you on bail
yes, Lordship.
beyond the provisions of law.
Lordship.
Tell us. You said there is a bar in law.
528, matlab,
Bar means it is a bar of the learned court below.
So we will ask them not to consider that bar in law. You did not participate in the investigation at all.
Lordship.
Whoever has been released on
Not
bail.
receive any summon is any notice issued by the police, Lordship, during the time of the
And you said
investigation,
2
Lordship.
persons have been released on bail.
2 person released on bail, Lordship. There one is my son and other is my husband, Lordship. They appeared before the police station, Lordship, and they
Were
they
taken
allowed-
into custody.
Yes, Lordship.
And then they were released on bail.
Bail, Lordship.
Then
and
they have received the summons.
Yes.
Then they have appeared.
appeared
After
and
appearance, what
remain
happened?
on previous bail, Lordship.
They were allowed to remain on previous
Yes,
bail.
Lordship. I am the wife of the petitioner member. I am the charge-sheeted accused of the number 2, Lordship.
why, when and son arrested? Why
Wife
don't-
does not know. Maybe she was not a party to the crime, so she does not know. Not inspiring, sir. Not confidence inspiring. But when the husband and the son are on bail, why put the wife behind bars at this stage? Investigation, she did not cooperate. Even it can also be a line of thought that the investigating officer could arrest the son and the father, but could not arrest the mother. Can it be so? So that part we will not go into. What will you do? Yes.
Next it is,
Next date is 12/3/26, Lordship.
326. We give her an interim protection, allow her to appear, file a regular petition, consider on merits. Will that?
Then no purpose will be served, Lordship.
But how are the others allowed to remain on previous bill? If no purpose is served,
Yes, Lordship.
why were the others allowed to remain on previous bill?
Yes, Lordship, I received the summon, Lordship.
Then you did not appear.
I will appear in the next date, Lordship. Last occasion when.
You are saying that there is a bar.
Yes, Lordship.
Then your husband and son have been allowed to remain on previous bail.
Yes.
If there is a bar,
They already allowed on regular bail, Lordship. Thereafter, after receiving the summon, Lordship, they appeared before the learned court below.
regular bail during investigation.
Yes, Lordship.
Am I wrong? They were on bail during investigation.
investigation, then.
So
someone
their
appear-
bail,
subsequently someone issued, they appeared and remain allowed to remain in previous bail as because.
So
they
their
are-
bail was considered. Why your bail will not be considered?
I'm not on regular bail, Lordship. I'm declared absconder, Lordship. That is the problem, Lordship.
Regarding that part, Malat, son and husband arrested. Why police not arrested her?
The absconder part we can ignore.
Arrest materials also you have to see, man.
No material is there, Lordship.
Against directly.
I'm not the named FI of the
Khatuna.
FI accused, Lordship.
She has to appear before the trial court in any case for the bail bond part, is it not?
I'm, Lordship, willing to participate in that trial, Lordship, because there.
What is that bar you are saying? What is that bar?
232, Lordship.
Huh?
232, the BNSS, Lordship.
232 regarding the lower court.
Getting the concept. One person is allowed, another person will not be allowed.
A committal court, Lordship.
Committal court, that's what cannot given.
Really?
Go to court of session because 302 is there. 302 is there, so it has to be committed to the court of session.
It is at the committal stage.
Yes, Lordship.
It is at the committal stage. It has not been sent yet. So therefore the CGM cannot grant you the bail. That is what you are saying. We'll grant her the bail till committal. Can it be done? On committal, she will appear.
Otherwise, Malat,
Something needs to be done. Either we have to interfere or we have to let her go inside. Father and son outside, why should the mother be inside?
well,
Some inherent powers we don't have.
For the ends of justice,
Or we don't
Lordship.
have to that extent.
For secure ends of justice, Lordship. This is a 57 years old.
Heard Mr. So-and-so Learned Counsel appearing for the petitioner, also heard Mr. Parashar Learned Counsel appearing, Learned APP. This revision petition had been filed. Praying for direction to direct the court of the additional Chief Judicial Magistrate Kamrup Metro to enlarge the petitioner on bail in the event of her appearance in connection with PRC case number so-and-so corresponding to Sonarpur PS case number so-and-so under section 120B/302 of the IPC. The Learned Counsel for the petitioner has submitted that the petitioner, her husband and her son are the charge sheeted accused in connection with the aforesaid case. In connection with PRC case number 2382 of 2023 full stop. The Learned Counsel for the petitioner has further submitted that the husband and the son of the petitioner have already entered appearance before the court of the Learned Additional CGM Kamrup Metro in connection with the case, and they were allowed to remain on previous bail till committal of the case. Full stop. The Learned Counsel for the petitioner has further submitted that the present petitioner was not arrested during the investigation process, and therefore she was not required to apply or be granted the privilege of regular bail at this stage. However, in the present circumstances, if she now enters appearance before the court of the learned, additional CGM Kamrup on the receipt of the summons, comma, due to the bar appearing at section 232 of the BNSS 2023, she may be taken into custody pending the committal of the case to the court of the learned, trial court, full stop. Learned trial court of competence, of competent jurisdiction, full stop. The learned counsel for the petitioner submitted that the petitioner is willing to participate in the trial proceedings, and therefore, given the protection, she would not be required to be taken into custody, even as her husband and son have been allowed to remain on previous bail till committal of the case before the learned trial court, full stop. We have heard the learned APP who has submitted that this case does not require the consideration of this court in view of the provisions of law.
Only one point, the page 24, it is part of the charge sheet, follow ground. Then accused Samad Ali with a sharp dove in his hand struck my father's neck. So Samad Ali, that is the husband.
Samad Ali is
Husband of the.
husband, so they are already there.
Regarding
That there is no allegation against this.
against Malata. He was in the.
She was present there, maybe. We have gone through the charge sheet submitted, and we have also considered the submissions made by the learned counsel for the parties. Full stop. We find that the charge sheet does not per se implicate the petitioner of any overt act. Full stop. Keeping in view the fact that the co-accused, that is the husband and the son of the petitioner, have been allowed to remain on previous bail, comma. This court directs that in the event of the petitioner appearing before the learned additional CJM Kamrup within a period of 15 days from today, she shall move an application bringing on record the orders passed by this court in the present matter and furnish a bail bond of surety of rupees 15,000, a bail bond of rupees 15,000 with two sureties of the like amount, subject to the satisfaction of the additional CGM. Full stop. On production of such bail bond and sureties, the learned CGM shall not remand the petitioner to judicial custody, but shall allow the petitioner to remain on bail till committal of the case to the learned trial court. Upon the trial being commenced in the trial court, the petitioner shall be at liberty to apply for regular bail during the period of trial. Will that do? Can we do that? Should we send her before the trial court? Satisfaction of the trial court. So learned is additional CGM Nukoba, learned session judge. Don't know where it is going.
That matter,
Let it be before the additional CGM.
already granted bail, then.
We have said that no, the satisfaction will be of the learned ACGM. We will not commit her to the.
Bond will be considered by the CGM. Already.
The bond will be committed.
Bail bond will be considered.
And he will allow her to remain on bail till the committal. When she will appear and.
Yes, then.
But you have to appear within the next 7 days.
Next 15 days, Lordship. She is very poor person, and Lordship, one thing, Lordship, if one bail or Lordship, then it will be Lordship. Very poor person, Lordship. He is a farmer, Lordship.
15,000. One surety korok and 15 days from today. 15 days from today.
surprise.
Disposed of.
My lord.
Yes.
In exercise of his power under section 3092C of the CRPC, the learned trial court, my lord, has dispensed with the cross-examination of one witness, and the another witness was allowed to leave the court as he had medical emergency, and cost of 2,000 was imposed upon the accused. Impugn order at page 19, annexure 2. Two witnesses were there before the court. The learned advocate, my lord, that was myself only, my lord. I failed to go, my lord, till 1 p.m., my lord. So at 1 p.m., learned trial court says that one witness allowed to go, leave the court, and again 2,000 imposed upon me, and another witness dispensed with. At 1 p.m., my lord. Sometimes it happens, my lord.
The tug of war is huge, Mr. Palasa. We fix at 12 and then they fix at 1 and then we call at 2. Yesterday also it happened before us only. A request was made to the court, take up the matter at 2. Calling the matters, we forgot. Matter came up before 2. None appears. Then at 2, the other person makes a request. And then we remember, yes, we had allowed. But
My lord, here, my lord, the witness PW4, Subhasis Borua, informed that he has medical emergency and he cannot wait further. As such, cross-examination of PW4, Subhasis Borua, is postponed with a cost of 2,000 to be paid by accused. My lord, he had medical emergency, my lord. He wanted to leave the court, cost upon the accused, my lord. It is his reason. He gave the reason. We have not filed any application for adjournment. We were ready to cross-examine.
what was the matter about?
And it is PC Act, my lord. Special Judge Assam, my lord. Then another witness, my lord, the witness PW5, Riten Kumar Bora, has been waiting for cross-examination as the learned engaged senior defense counsel did not appear. So cross-examination of PW5 is dispensed with. As
What
per
about service and respondent number 2?
person. My lord, state, my lord, he is a police officer, my lord. So state will appear, my lord. He was the informant. Informant.
What do you say, sir?
Already. I think, my lord, there is an order, my lord, taking care of this.
What do you, no, what do you say about that order? These are matters which do not need prolongation, sir. Either we close it or we allow it. One of the two. If you can show us anything that this needs to be dismissed, we dismiss it right away.
Regarding that, PW number 4, he has emergency, yes, medical emergency, but
So that cost part we may not interfere. There was a delay, we may not interfere, we'll bring it down to 1,000. Okay, then?
regarding dispense with.
Dispensing, why dispensing? PCA. So 1,000 cost for him to come again. Ultimately 2,000.
My lord, 309.
We'll allow the cross-examinations. Have you cross-examined 4?
No.
No.
Why?
He went back, my lord. Due to
No, as such cross-examination 4 is postponed.
postpone, my lord.
So whether they
He has
postpone
not come
after that
on
postponement,
last date, he has not.
huh?
On last date, he has not turned up.
But he will come.
He will come.
So you can yet cross-examine PW4 with subject to
yes.
cost of rupees 2,000. You are agree with the 2,000?
Yes, my lord.
We will give it to the next person. Riten Bora.
My lord,
We'll make it 1,000.
for a moment, my lord.
We'll make it 1,000.
3092C, my lord. 3092C, my lord. It says, where a witness is present in court, but a party or his pleader is not present, or the party or his pleader, though present in court, is not ready to cross-examine the witness, the court may, if it thinks fit, record the statement of the witness and pass such order as it.
Is the attempt to prolong the cross-examination or is the attempt to go ahead with it?
My lord.
We want something solid now. See, if this goes on, we'll just fix another date, keep it this and that, and it keep on prolonging there. You want that to happen, or you want that, yes, I will examine my grievances PW5 cross-examination, I'll have it done. Since he had to go back on that day, he has to come back again, since it was a judicial order, which deemed it fit at that point of time.
He could have waited, my lord. That day we have not filed any application. It was 1 p.m., my lord. It is recorded. Learned Senior Defense Counsel did not appear till 1 p.m. It was 1 PM, my lord. He could have
What
waited.
about,
we could
what
have
about, but the
cross-examined.
party or his pleader is not present?
My lord, we were present there just till 1, it was at 1 PM, my lord. We could have done it just after that. My lord, what happens, my lord? 1 PM, my lord. After 1 PM, we go and contact cases
We'll
there.
just say it to you in this manner.
My lord,
We will just put it to you in this manner. When we say present, we say when the matter is called upon. The presence is required then. The presence is not to be throughout any time of the day to the convenience of the councils or the parties. Because you are free, we are bound. So we will not wait. We will take it as things moves on the chain. When the matter is called, you are not there. So it has been closed. We do not agree that it should have been closed with that.
but council was
With
present
that
with the
strike.
accused. My junior was there, my lord.
He could have crossed. Presence
Definitely, my lord.
presence will not mean standing inside the court. We have been encouraging people, please speak up. We have been asking the councils who are not so senior to speak up, because we want them to speak up. Once the band and the gown is worn, we'll wait for a senior to come to cross, then better not wait. Is it not? They are there to make a request for a delay on an adjournment. Cannot guarantee. Is it not?
It is
So
fine, but
the
my lord,
best we can do is close it today, giving you the opportunity to cross-examine respondent PW number 5, and the cost part we'll consider it bringing it down to 1,000 to be paid to the respondent number to the PW number 5 for securing his attendance.
yes, that can be done, madam. My lord,
Your matter can go on
my lord.
peacefully without worrying about
Not
the
to
High Court.
PW4, my lord. He left for his own emergency, my lord.
I will cut it off from PW4.
Yes,
We'll
ma'am.
bring it down to PW5,
5, my lord.
and we will impose that cost because he has to come back again.
Yes, yes.
Heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard Mr. K.K. Parashar learned APP appearing in the matter, who appears both for the state of Assam and for the informant in the case. Full stop. The grievance raised in this petition is against the order dated 17/9/2025 passed by the Court of the Special Judge Assam Guwahati in special case number 15 of 2023, whereby the PW number 4, whereby the cross-examination of the PW number 4 was postponed with the cost of ₹2,000, and the cross-examination of PW number 5 was dispensed with in exercise of authority under provisions of section 3092C of the CRPC. Full stop. The learned counsel appearing for the petitioner submitted that on the said day, the learned counsel for the petitioner was present in the court, but he was not available till 1 PM when the order was passed. Full stop. There was a bona fide intention to take up the cross-examination after 1 PM since the learned counsel for the petitioner was otherwise engaged. Full stop. The learned counsel for the petitioner submitted that the ends of justice would be met if the cross-examination of the PW number 5 is allowed subject to such just conditions as this court may impose, and that the imposition of cost on the accused with regard to the postponement of the cross-examination of the PW number 4 fixed at ₹2,000 is on the higher side and needs interference of this court. Full stop. The learned APP has submitted that although the learned counsel for the petitioner has submitted that he was available for cross-examination, the orders passed by the learned trial court clearly records that the defense counsel did not appear till 1 PM. Full stop. Without going into the merits of the submissions made by by both the contesting parties, this court deems it fit to direct to interfere with the dispensation of the cross-examination of the PW number 5 as directed in order dated 79-2025, full stop. It is accordingly interfered with. The PW number, the accused shall be given the opportunity to cross-examine the PW number 5 in accordance with law by the learned trial court on a date to be fixed by the learned trial court for such cross-examination, full stop. On the failure of the accused to effectuate cross-examination on the fixed date, comma, the learned trial court would be at liberty to pass such necessary orders as may be required, full stop. Further, it is further, this court directs that the payment of a cost on the postponement of the cross-examination of PW number 4 is interfered with, full stop. However, a cost of rupees 1,000 be paid to the PW number 5 on his appearance, since he has to reappear in the matter due to the reappear in the matter now, full stop. Anything further? We'll see the order if we need to add anything. Criminal petition accordingly disposed of. Continue with the trial peacefully.
My lord, in the trial court record, my lord, there is not a single adjournment. Till date, my lord. And my lord, all the cases, my lord, conducted by us.
It is not only the pleadings and the submissions always which
Not a single adjournment, my lord.
which gets an order from this court. It is also the conduct of the councils known. Yes, next.
Grateful, my lord.
Hmm? Hmm.
May please a lot.
Yes, sir.
It's a regular bail application, my lord.
Hmm.
It's a regular bail application, my lord. I was granted interim bail, my lord, by order dated 25/11/24.
25/11.
There is a office note of the registry in the first part of the. It has to go before the appropriate bench, probably.
Which one?
The file also, there is a note from the registry.
No, আগতে এবাৰ ৰিজেক্ট হৈছে সেইকাৰণে তেওঁ তাত পঠাইছিল।
That 99/2024 is what you are saying. It is to state here that Honorable Justice so-and-so had ordered it 24, it was pleased to dismiss the bail application. That note.
Therefore, not order, Lordship. A registry's note is there, Lordship.
I'm reading the note.
Yes.
It is to state that that Honorable Justice so-and-so had ordered it that so-and-so was pleased to dismiss this bail application as not pressed to one of the accused
Co-accused, yes.
arising out of the same PS case number. It is placed before. Then what happened?
My lord, the case came up before Justice Saikia, my lord, and he granted, his lordship has granted interim bail, my lord, on 25/11/24. Thereafter, my lord, records were called for, my lord. My prayer before your lordship, my lord, is that interim order may be made absolute, my lord. If a lordship kindly turns to page.
It came up before him, then should it not be disposed by him now?
Yes.
I have no.
I think that is the procedure followed because it's the notification it is given here. You can go through it. All bail applications arising out of the same FIR which are filed in the court are to be listed before the same honorable judge who has previously disposed of bail applications pertaining to the same or different accused persons in the same FIR.
There is a confusion, my lord, because in the instant case, my lord, I'm not pressing, my lord, today, my lord. Just to point out one thing, my lord. My lord, here there are two accused, my lord.
One of them had withdrawn.
I first withdrawn. Again, I filed an application. So that was placed before Justice Saikia. And the other accused, my lord, that case came up before Justice, my lord, Pathak, my lord, and he granted absolute bail, my lord.
It could be done.
What can be done, my lord?
I may overlook the notification by mistake.
Maybe, my lord.
But if it is pointed out that by mistake goes.
Let it be.
List this matter before the appropriate bench as per notification, registry, learned APP submits that the matter requires to be listed before the appropriate bench as per the notification, registry to verify and list accordingly. The name is also written on the top. I don't know why it has come to me. No, then at a later stage. But add two koribo, attention jetia ahe. What is 17? Item 16, the objections filed have not yet come. So we have asked the matter to be called at 2. The objections are not here anyway. We have to keep it. At 2 we'll take it.
Okay.
Yes, 17.
With due permission of your lordship, I would like to place the certified copy of the learned port below, wherein the charge sheet was returned back as it came incomplete without FSL.
Yes, sir. If the charge sheet is without the FSL, is it a charge sheet submitted in law? Part charge sheet will it not give rise to default bail?
Lordship, it has been held by recently by the Supreme Court also,
Mm.
Lordship, that it can be, FSL report can be given at a later stage. Supplementary charge sheet, by way of an
So
supplementary.
it does not become a part charge sheet.
Yes.
No, we allowing it to be given at a later stage is one thing.
Yes.
Someone must have objected to it.
Form of supplementary charge.
But
Then it will be treated as a, if it given as part, Lordship, without the FSL report, it will be.
it is still
treated-
treated as a
Yes,
charge sheet.
Yes.
Can we have that law? We'll have it at 2. No difficulty. We'll have it
But
at
it
2.
shall carry,
If it has
it shall
been sent back.
Unless you hear him, you will not be able to
Yes, Lordship.
answer what he's putting up to me.
At 2, Lordship.
At 2, because see, sir, this is not Kaun Banega Crorepati. You have to be quick. It is, you have to be correct.
Yes.
That is also, listen to him fully. Yes. You are saying that even a charge sheet without an FSL would still be a charge sheet good enough to deny him the default bail. That is what he's trying to bring in. That is your only ground. It was a part charge sheet.
Lordship, learned port below has found that he cannot take the cognizance in the case.
I understand.
Unless it comes in complete form.
That is his understanding. If the Supreme Court's understanding is different,
But to my limited understanding, there should be it should carry a.
you must have some other ground also.
Should carry a. I have the.
Other grounds also would be
merit I
there,
have
so
the
we'll
grounds
take up
for
that
it.
ground.
Merit, I have the grounds. I will.
If you get it,
To it.
on this, we don't go into the
For
others.
other grounds, Lordship, then I will have to take instruction if the charge sheet has been submitted in the meantime, or if the CD is available, then we'll have to have the CD.
Hmm.
If he pleads on other grounds,
Uh-huh.
because without the case diary or the charge sheet, Lordship, it will be difficult.
It have, nothing has come now.
No, nothing has come, Lordship.
Why? If the charge sheet has been submitted, the FSL part has been, if only the FSL part remains.
By this order, Lordship, I have seen, Lordship, the charge sheet was sent back, Lordship. The
Mm.
court did not accept the charge sheet.
Mm.
So that means, Lordship, that investigation is still pending.
So the CD would be there.
CD will be necessary then. That is the difficulty. Or in the meantime, Lordship, because it is a order of October,
Mm.
1st of October. So, Lordship, in the meantime, if charge sheet has been submitted.
When were you arrested?
Lordship, on 6th of August.
6th of August. I think
Lordship,
we'll keep it at 2.
No.
We'll see whether we can further detention.
At 2, Lordship.
Why so much of cough syrup is required when one is not selling it?
Lordship,
Can it be drunk? I'm not on the intoxication part. Such amount of liquid, can someone drink it?
And contrary to it,
10
Lordship,
cartoons?
Ascaf, which the cough syrup is the
We are
generic
taking it to be
capsule.
plain water.
Yeah.
But will you be able to drink 10 cartons?
No, Lordship.
Why do you keep it at home then?
Lordship, I am not involved in the series. I
Then-
am just the crossing part I have taken. I am a godown keeper of a logistic company, Lordship. I
Ah.
took the crossing. Someone else booked with me for an amount of rupees 450. I taken in the name of Johnson's Baby Oil. The bill was raised in the name of Johnson's Baby Oil.
Oh, you are a courier or a transporter?
Yes, Lordship.
Oh, they are the.
My
They have a very
it's
good
not-
history.
The case is revolving last 2 months. Round and round.
around the case diary. Sir, please find out whether it is a case diary or charge sheet we should call for, if necessary. Otherwise, we may look at the other things also.
As regards the rejection of the charge sheet by the learned court below,
Ah.
on that appreciation. At 2 o'clock.
He was only transporting how many? 10 cartoons
30
of baby oil.
Lordship, I have also annexed the dispatch manifest, Lordship, wherein it is clearly mentioned that Airways Logistics have booked with us. We are Sai Logistics.
Hmm.
So I have annexed the manifest, dispatch manifest, the
There is
bill,
a
the
declaration by
challan.
the customer also.
Declaration is not found here, but the manifest, Lordship, with other documents, the annexure 6, page 31.
We'll have it at 2.
At 2. Right.
একদম উপর উপর সব চকু ফুৰাই দিওঁ টাইম আছে 18
This matter has been listed number of occasions. That is submitted with.
charge sheet has been submitted, sir. What was the allegation against you?
Against, on the basis of one prime accused, 5 other co-accused has been arrested in connection with this case.
Commercial quantity.
But we are not involved in this case. There are only, so section 67 of NDPS Act bars the confession of a accused person regarding arrest of other person. Section 67 of the NDPS Act.
The statement
bars-
cannot be used against other
Yes,
co-accused person. Yes.
Only, this is the ground, if you lordship would prove, and peruse the forwarding report, page 16, my lord. There are 5 other accused persons. arrested.
Page
16, annex of
16.
There are
Comprising so and so, one person of job coming from so and so, they met at so and so. How many are here in this bill petition?
only one prime accused is Sabor Ali, whose name is involved in the FIR. Our names are not involved in the FIR. Lordship may
No, I'm asking how many are there in this petition? One.
only one arrested, Sabor Ali. But in this case, I am for the one petitioner.
Mhm.
Name of Sabor Ali is appeared at page 14. I am behind.
Arrested on the statement of the other persons. Any
Yes,
any
prime
any
accused.
recovery is made? Nothing.
Nothing recovered. So 67 and DPS Act bar.
F2.
That's it submitted here.
Charge sheet submitted. Find out whether you want to ask to call for the scan copy or you want to go and appear there. Pray for regular bill.
Lordship may kindly dispose of it.
Dispose it of. Allowing you to go to the go before the charge sheet number
176/25 dated 30/08/2020.
let the council praise that council of the petitioner praise to koribole. He may be allowed this bill petition may be closed, allowing the petitioner to approach the trial court praying for regular bail. Full stop. Liberty granted. Bail application closed. Thank you. Alien objection, huh?
What's the last order, man?
Last order was for
Used to bring some instruction, but the basic question was that we have given the wrong address to the family. But address here was fine from coming from complaint, same address, which is in the FIR, that is in the charge sheet, in my address also, same address was given, man. They have stated that it was not.
39 of my affidavit, bring on the record. Page 39 is a letter dated, received from Tirupati. Where the para 2. This regard, the outcome observation of the verification and inquiry conducted, the subject cases are as follows. The address of Ramdi Anand and Ramesh Reddy as provided in the above referred letter where stated and found that the persons are not residing at the place and whereabout are not known to the neighbors. Then B, further Sri Ramesh Reddy was contacted on mobile number so and so. He expressed that he is undergoing treatment for cancer at Chennai. On further inquiry, it was found that he is staying at Sulurpeta and not in the address of it is so and so. However, Sri Ramesh Reddy has not disclosed any proof of identity address.
So who is Ramesh Reddy, my lord?
Hmm?
Who is this person, my Ramesh Reddy, my lord?
You have the,
During
do you
investigation,
have the objection with you?
Yes, today, my lord, this, today I got it.
The addresses of Pamidi Anand and Ramesh Reddy as provided in the above referred letter. So, Ramesh Reddy was
during investigation, its name.
who is the Ramesh Reddy here?
If, during the investigation, his name cropped up.
No, Ramesh Reddy, we are not required to know. We are
Yes.
required to know about Pamidi.
Pamidi.
And
Page 30.
Pamidi
Provided in the.
found
above
that
record.
persons are not residing at that place, at the given address.
Same address, when this husband has given, your lordship, the address which was only in page 30, 48 notice matters only Pamidi, wife of so and so, mobile number was given. So where they visited, whether visited is all along there, my lord. This is my statement, all along there.
We do not.
There is the question of that Keshav Reddy or somebody else, my lord. Reddy. Ramesh Reddy.
Do you dispute the address?
No, I never dispute, my lord. Address which was given, your lordship kindly say, address is there in the husband that your lordship will find page 12. Page 12. Complete. This address is known to them.
This is the address they are saying that Pamidi was not found there.
Yes. This is a report from the report.
When
has come from-
they visited, my lord.
Huh?
You must kindly see the date of 48 notice,
Hmm.
page 30. It is dated 17/5.
Date of?
Page 30, my lord, 30. And it was received by the Anand, her husband. It's not her signature, my lord. So that itself was, my
No,
lord.
that lady was, she is not available here. How can she sign it?
That's true, my
She is
lord.
there.
He cannot, she is to sign after receipt of that clear, but she is to be communicated. What is the, when
The
they have
issue now becomes one of fact finding whether they went there
that is, when they have visited, time is not
and
there.
when they have visited.
No, time is not there, madam, in the affidavit. The address is, in this regard, outcome, further, they have visited. The addresses of Sri Pamidi Anand and Sri Ramesh Reddy, I don't know who is he, madam. Ramesh Reddy, as provided in the above referred letter.
7. Oh, sir. When were you arrested? 29,
Yes.
25/9.
Yes,
17/5.
17/5, madam.
On 17/5.
17/5.
And if you see the first paragraph of your letter, sir,
Lordship, may please to see reference.
reference to
Is invited to the letter received from so and so dated 19.
19/7. So from 17/5 to 19/7.
Lordship, please to see page
And
38.
38.
Lordship,
That is explained.
under section 48.
Hmm.
48(3) provides.
This was sent to, this was information to Pamidi Saroja.
Lordship,
Beneath you are writing that it is informed to cellular calling. Now from 17/5, the letter that you have produced now, You wrote to that
But-
Assistant Commissioner of Customs on 19/7.
19/7 and 21.
So 19/7.
Let me please to say.
So 17/5 and 19/7 is a gap of
No,
2
no,
months.
It is correct. But see, may please to see what section 48 provides.
Hmm.
Section 48(3).
What does it provide?
Entry, section 48(3). An entry.
Will come from one.
So one is complied with. Immediately she was informed over telephone as provided by the accused. Then section 48(3) provides an entry of the effect as to who has been informed of the arrestee of such person shall be made in the books to be
So-
kept in the police station.
So the entry has to be with reference to who was informed,
Yes, Lord.
not whom it was addressed to.
Lordship,
It can be addressed to,
anybody. Lord.
but it may not be informed as of yet. So from 19/7/2025 to 25/9/2025, was
Lordship,
it
Lordship,
even
please
informed?
See the office order sheet, Lordship.
Office order sheet at
A flag mark, it was informed immediately on the day of arrest, Lordship.
over telephone. That would not suffice,
No,
perhaps.
yeah, that will not suffice.
That is suffice as per the judgment of this honorable court, Lordship.
That was a little different.
Yes. Here, Lordship, here.
We have observed that in one of our orders that
Yes, Lordship.
situation was different.
Yes, Lordship, here what happened, Lordship, immediately the letter
19/5.
sent to the,
Hmm?
he was informed over telephone, Lordship. Order sheet is there. We have made the specific note that on the same day it was informed to the wife of the petitioner, Lordship.
This first flag mark.
Probably second flag mark. Small note is there.
Arrested on
Tested on
17/5.
17/5/25.
17/5.
Lordship, recently Supreme Court says that WhatsApp message is not sufficient compliance. Yeah, that is relating to service matter. But today I have not worked as a.
No, but WhatsApp, if WhatsApp is not sufficient, would a phone call, your recording that a phone call was made will be
Yes,
sufficient?
Lordship, because this honorable court observed that Lordship, yesterday I submitted on judgment.
That judgment is gone. Test memo. Arrest memo and then
Arrest memo,
then
then section 47 notice,
huh?
48,
Hmm.
then Lordship, communication received from custom Tirupati Lord.
Huh? No, you will have to show us that entry.
Lordship, that is, Lordship, I'll.
48, his signature. It is there on the notice.
It was translated in his language, Lordship.
Yes. But I am yet to find out the GD entry.
Lordship, I'll point out from my.
There has to be some GD entry, I suppose.
Entry in the office file. I'll point out from Lord.
Shall be made in a book to be kept in the police station, not on the file, on the book to be kept at the police station.
Lordship,
Yes, which paragraph you were referring to over phone?
Lordship, 48 notice. Lord.
Over phone has been accepted, you say.
Yes, sir.
Paragraph?
And submitting judgment. Lord. In bail application 1462/25.
No, 322/2025.
Same Lordship.
3200 of 2025. You have given us this, if I'm not wrong.
Oh, this is, I have given.
This you have given. Which judgment have you given?
For, to give.
This is, I have given that one, earlier one.
अपनी accelerate. No. Aim board.
The arrest was intimated to his family on the same day, 17/5/2025. That sentence you are referring to?
Yes.
Huh?
Yes.
No, since
That
we
is,
are,
as per
an
43.
entry of the fact has to, as to who has been informed, shall be made in a book
Yes, sir.
to be kept
The police
in the police station.
station. We are
So,
maintaining file Lordship. Because we are.
of the
actually-
same, on the same file you make a note.
Cannot be, madam. Register one.
No, Lordship, we are the specified agency. We are not maintaining case diary, Lordship. And this is our record.
It is not required to be maintained in a case diary. It is required to be maintained in a book,
Then
which
Lordship-
is kept permanently in the police station.
If it is Lordship, it is there, then Lordship may observe, will make necessary correction in our office. Lordship.
Make us the policy maker and the lawmaker.
No, Lordship, section
No,
43 is clear.
Mr. KL,
Lordship.
Lordship will do this, Lordship will do that. Lordship knows what to do.
Not submitting, I am submitting 48.
It is for you to follow the law.
Lordship, we are following the law. We are maintaining in the case diary, Lordship. This is our rest.
Kindly read it once again.
Yes, Lordship.
48(3).
48(3). An entry of the fact as to whom has been informed of the arrest, such person shall be made in a book to be kept in the police station.
I did not hear you again.
An entry of the fact as to who has been informed of the arrest of such person shall be made in book to be kept in the police station in such form as the state government may by rules provide. Lordship, here the NCB is a central agency. They are not maintaining any Lordship case diary, Lordship. So in the register, in the file which are maintained by the agency, we have make not here, Lordship. This is my humble submission.
Here the notices were also sent through speed posts.
Through Lordship agency of the Tripura by the department.
Here in this particular case,
Yes, it was sent through Lordship, may please to see page 48.
the quantity was confiscated from the truck.
The truck one.
It is
Truck which he was driving.
Yes. Lordship may please to see page 35. Everything is noted here, Lord. There was a secret chamber in the truck. From that, Lordship, goods were seized. It is mentioned in page 35. Lordship. Then paragraph 22 in bail application number 1462.
Reading that, I've read that. Your reliance should be on para 20.
22.
It appears on the case diary that additionally the family members of the petitioners were also telephonically informed. That is at para 20.
Then let's say the finding of the court is at paragraph 22.
Hmm?
Paragraph 22.
Paragraph 22 is the sufficiency of the grounds. We are not on the sufficiency of the grounds as of now. We are trying to find out whether the family had been informed in writing.
Yes.
Is
Here
what
in this,
we are
in
trying
this
to.
case, what happened? Same lordship, there was a delay in
There was another judgment, huh?
this case, in this case, which I have given to the lordship. In this case, what happened, lordship, the information was given after a week. Then the letter was received by them. It was sent through post. It was admitted by the petitioner. Here in the case in hand, lordship, the notice, initially she was informed over telephone. Then notice was sent through Assistant Commissioner Tirupati. Then this letter came to us, Lord. That the address provided by the petitioner is not correct.
Mr. Chaudhary, in this case that you have referred to,
14, paragraph 14.
mere statement in the said notice that Chandradhar Das had been intimated about the arrest
Yes.
cannot be over telephone, cannot be regarded as compliance of the requirement of communicating grounds of arrest in writing. Mere presence at the time when the statement of the wife was recorded is also not sufficient. Though the wife was present, there is no material on record to indicate that the communication of ground of arrest in writing was made even to her. Under those circumstances, court said that we cannot believe that it was given to in writing.
Their whole question matter to whom they have given. They are saying that the address is not found. Address is it is their address. They have given address of the accused man.
No, which you had provided.
I have provided because I was there. My card was there. Everything was seized. That's the address I
Anything
have
to
provided.
show that any document in the bail petition to show that that is your last known address, or that is an address that you have been using?
That one affidavit file, my lord, this person, my lord.
Huh?
Affidavit also you also can see, my lord.
Affidavit is by
Who?
some other person. That was-
Affidavit is by some other person.
Yes, Lord, yes.
It is from Chittoor. If you go by the address given in the affidavit, then their communication that everybody has shifted to
Communication, my
Chittoor.
lord, this address, if this is the address, my lord, should be the address which I have given, they have, my lord, mentioned in the complaint. There is, and I still stick to that, my lord. This is my address. Still, I say that this is my address. And it is cannot be that, my lord, they have gone there and they did not find anybody in the family, my lord. And when they have visited, that is also not there.
That is what the two things are disturbing us, Mr. Kel. One, from May to July,
Right.
nothing. Whether it was delivered, not delivered, what happened to it, what happened, what didn't happen, nothing on it. In your July letter, they respond in September, saying that we could not find it. And they do not say when they have gone.
Of course, it is not there.
So,
Letter is there.
so now they have also stated in that letter that they have sent you the some of the documents. Can you find the Aadhaar card, what not, what? They've stated about some few things, is it not? Huh?
That's it.
They have referred to a few documents. Do you see?
The copies of the vehicle registration, license, license obtained from Sri Ramesh Reddy here.
This person must have been carrying some identification with him.
That is why that address.
The accused,
Definitely.
some documents should be there.
The list.
What is the address disclosed in that document? The quantity which was,
The Caesar list is not. My lord, Caesar list is there, my lord, right?
I just want to know, 674 kgs.
Ganja mine.
Ganja is commercial quantity.
Huh?
Ganja is commercial.
Ganja.
Ganja
That
is
is
commercial
not
quantity. In a
disputed.
truck that he was found to be driving,
Yes.
in a secret compartment. We are with you. The notice you say was informed telephonically at a particular number, and there is no noting to say that you inquired about the address where it is to be sent. There is no the notice was sent electronically, WhatsApp, whatever manner. Nothing is there. You have sent it to,
Assistant Commissioner Tirupati.
and Assistant Commissioner Tirupati speaks of a letter of July, not of May.
Yes.
He speaks of a letter of July. In the case that you have given us, the judgment that you have given us, there, the notings are there in the case diary, and the notice which was sent was also of that date. The court found that. If I'm not wrong, the court has found
Here notice is of the same date, Lord.
when was it sent was an issue there. That could not be shown by the petitioner. See,
Lordship, may I please to see page 39. Subject, subject, page 39.
we will come to that. We were on the judgment that you had given us.
Yes, Lord. That's well judgment.
He submits from the endorsement so and so appearing on the said envelope. It appears that the said notice was said on 28/12/2024 only.
It was.
So therefore, the court said that we cannot believe that it is on 28/12/2024 because notice itself is dated on 13/12. So 15 days they would keep it lying. You have not shown by any manner is what the court held in that case. In your present case, admitted position, Assistant Commissioner is saying that your letter is dated July.
There is a subject.
Now show us from some record that you sent it to the Assistant Commissioner on the same day or on the day thereafter. You need your records back, we can give it back.
Further, Lordship, I
Just
will
let us
inform
go
the
through
IO
once.
that final complaint has already been filed in this.
Huh?
Final complaint has already been filed in this case. That is informed by the
Is
IO.
the settled law is even after filing of the charge sheet, if there was a violation of 22(1) or 22(2),
In but one case.
we
Lordship,
can interfere.
Stand minor.
We can then interfere.
No, Lordship, I am not on that. I'm just informing your Lordship. What is the?
Yes, sir. That is last
I am
We-
I'm not shifting my stand.
We did not for once say, Mr. KL, we did not for once think that Mr. KL would make a submission which is not required to be considered by the court. Every sentence you say, we try to catch it and find out why you made that statement. And please do not reply to him. He would not be replying to you.
Definitely, Lord. I'm not.
We don't want it, that in this court.
Case. It will be-
Ah, we got it. You send a letter to the Assistant Deputy Commissioner on 21/7
Lordship, there are two letters.
and
19/7.
yes, 19/7. So what between May and
That's
July?
it. In question 12.
Then it goes, then your judgment doesn't come into play.
No,
If you are sending the information to the Assistant Commissioner on 19th of July, can it be by any stretch of imagination said that you had informed them immediately on the arrest? These 2 months, can we call it immediately, sir?
Lordship, on telephone, it was, she was informed on the same day. That is there. And Lordship, although.
That is a statement made by your officer, recorded in that, this thing, the time of information, the duration of the call, the person who answered it.
Wife.
How do we know? It's an assumption.
In note, Lordship, it is, it is written that family member was informed. Lord. The note two.
The arrest was intimated to his family.
Okay.
Brother, son, sister, father, mother, wife. We consider that family.
Normally it comes to the wife, Lord.
No, it does not. We will not assume. We cannot assume, in fact. Is this May to July? We are trying to bring it to as short an compass as we can.
No, Lordship, I'm.
The recovery not being disputed.
Recovery is there, Lordship, and he is in.
The recovery is there, everything is there. 48 is the only issue. 48, we will even go by the telephone. Had the appropriate details been there. This was the person, because your note which you are referring on, you can again go through it. if this particular note says that it was informed to the wife, since you are depending on the note. Okay, because
So page 38 also clear.
under 48, it is said wife of accused. 48 notice says so. The note does not say so. The note says to his family. Number one. Number two, the time of the call, the duration of the call, or whether what was informed. That we did not find in the note. A note may not contain that all. Fine. Now the written question comes. Not sent on WhatsApp.
Yes. it is
From
not
May
sent.
to July, no communication between between your and the office of the assistant commissioner, and therefore it has to be presumed that it was sent to the assistant commissioner to be delivered on 19/7 at the earliest. This 2-month gap. Your husband has been arrested. That is given over the phone. That information is there. These are the circumstances in which he has been arrested. When he is under arrest, they have to make an arrangement. That is the law, I think, that the accused should get that.
Lordship, then Mihir's case, that purpose of section 48 is to inform the family members, so they can approach the court seeking bail. Lordship, here, Lordship.
No, we will not interpret what can be drawn out of Supreme Court. Judgments are not for interpretation, sorry.
That is provided in Supreme Court.
So he missed it that part of time? It goes.
No, Lordship.
That is what we have understood.
Lordship, please to see when she approach this court for seeking bail.
Huh?
And on which date they.
First bail petition?
Yes. Sir. This instant petition was on 5th of September.
Which one?
This petition.
True.
These are considering. Page 11, Lordship.
Page 11. Huh? Of what?
This bail eclipse.
It is an affidavit.
Yes, affidavit. I'm pointing out the affidavit.
5th day of September, yes.
Lordship, see who is the petitioner, who is the sworn the affidavit, Lordship.
Brother.
Related brother of petitioner in the
done.
instant case and taking steps in the instant case on behalf of the petitioner. And as such, I'm fully acquainted with the facts and circumstances of the case.
So we'll presume that that July 1, they have received that July 1. Now the brother has come running.
Whatever it may be, but Lordship, information was provided to the to family members. That's why they have approached the court.
In September.
Whatever it may be, Lordship, as soon as Lordship, probably they have approached the learned sessions at Silchar also. Learned sessions at Silchar also. Yes, Lordship. Page.
Yes, sir. This page 26, Mr. Chaudhary, why should we disbelieve the learned remand magistrate? Page 26.
Page 26
6.
of my petition.
Yes. Why should we disbelieve him?
26. Let me see. Which one? First one?
Page 20.
First paragraph.
Annexure 4.
Asked. The accused stated that he and his members' relatives have been properly informed by police regarding the grounds of his arrest.
So at that point of time,
that saying will not do, my lord. It must be seen.
it is the record of a
He is the
judicial.
person in custody, my lord. He does not know what is there, my lord. He simply says that telephonic information was there. From him, telephone number was taken, my lord. In that, neither grounds, nothing is there, my lord. The letter which I have annexed, my lord. Page 30. Why simply he is saying, my lord, he is not bound to say anything. Even if he says it is not bound, my lord. And he has said certainly, my lord, because he was under custody.
His grounds of arrest are possession of commercial quantity of ganja.
That
The
I am
ground
not,
is there.
not merit, my lord. Merit
but-
is there, he is, my lord, and the possession, that is that law, my lord, during time of trial, that will be seen, my lord.
You have to tell us why we should disbelieve the remand magistrate.
No, I
Remand
am
judge.
disputing, my lord. One being asked, the accused person stated that he and his family members, relatives have been properly informed. He has stated, it is there to say, my lord, whether they are properly informed or not. Who has been informed? Till now, my lord, we have not been known from
My family has not been informed.
not at all, my lord. We have stated not at all, my lord.
No, you have stated, someone else has sworn in
They are saying
affidavit saying that the.
My lord, members of family, as I have heard from my learned friend notes, my lord. It was informed the family. Now I am saying, my lord, in that letter, the grounds also not there. How they accused, my lord, on that day, how page 30, my lord, nothing is there, my lord. He is saying the grounds also there. He might have informed. That is another aspect, madam.
This is a statement recorded by
This is
Chief Judicial Magistrate, who is the remand magistrate and who is required under the law. If I'm not wrong, let us again go.
that is what the accused person.
It is the duty of the magistrate to satisfy himself that the requirements of subsection 2 and 3 have been complied with. He made that effort. The petitioner does not, the accused did not make any ground.
But he says this remand is justified or not. Arrest is justified or not. That is his to see.
No, 2 and 3.
Yes. He cannot see what about the 21.
No, 2 and 3, yes, he can see into 2 and 3.
No.
That
but
his family has been informed.
family
2
has
and
been
3.
informed.
3.
But how informed? That Bihan Kumar come, Keshav Reddy come, madam. This is the question, madam. Magistrate did not say how it was informed. He did not deal with that question, madam.
Any other ground, sir?
Magistrate. The 40 is the only ground in my case, madam, 40 is. My specific case is that, my lord, the address also your lordship will find. That, and magistrate, madam, in what reference this order was passed, your lord, can see, madam. 18.5. He is escorted by IO, seen the accused person along with so-and-so, one goes to the medical report, one being further asked, he has stated that he has not engaged lawyer from his own, send a copy, then on being asked, all right, your lordship has seen. In view of the above, I am satisfied the accused person are arrested on sufficient ground. Arrested on sufficient ground.
Therefore,
Then thereafter, and while arresting him, guideline laid down by the Honorable Supreme Court and Bihan Kumar are duly followed. That your lordship is to see whether Bihan Kumar followed or not, madam.
he was satisfied.
Now kindly see Bihan Kumar, madam. Bihan Kumar paragraph, my lord, 21. Paragraph 21. Bihan Kumar. Whether I had dealt with this question, my lord? Bihan Kumar. Your lordship kindly see paragraph 20. Paragraph Bihan Kumar. Para. Bihan Kumar.
এটা সেট বনাব লাগিব
Yes. Yes, madam.
কেইটামান জাজমেন্টৰ এটা সেট বনাই থব লাগিব এতিয়া যদি
Bihan Kumar paragraph.
কিহৰ লিখিছে আছে নেকি লগত কিহত আছে
20, paragraph 13. 21. Filing charge sheet. 126 information. Paragraph 26, madam.
Para 26.
6.
The stand taken before the High Court.
Yes.
The stand taken before the High Court, that paragraph.
Page 26, just requirement information, a person arrested, ground of arrest is a mandatory requirement under Article 21. Now, only question, as your lordship has rightly stated, my lord, that information, initially they themselves said in their own petition, own forwarding report, my lord, that they informed to my wife over telephone. Your lordship has seen their version, my lord. That is page 14, page 14. Now the grounds and anything informed to whom? Here they have stated they have informed the wife. Simply information will not do. Whether the details was given to me or the assistant counsel, even after 2 months also, my lord. That page 14, paragraph 6. It is their case they have informed to the wife. Nothing more we find from the records, my lord. What inform, what is the inform, nothing, but it must be meaningful and purposeful. Merely information will not do.
Mr. Kyal. Paragraph 26, you said, na? The stand taken before the High Court, Bihan Kumar, was that the appellant's wife was informed about the arrest. We have perused the arrest memo, same contains only so-and-so. Information about the arrest is completely different from the information about the grounds of arrest. Your note says arrest was intimated.
Please to see the 48 notice also. What information has been given to her?
48 notice was given to the, read out to the
Yes.
Wife is not the note. I think we need to close this. We'll keep everybody waiting otherwise. We have to
sir, I
make
want
up our
to place
minds.
paragraph 7 of bail application.
Huh?
What is this is the second one. Paragraph 7, page 7.
To bail application.
Bail application.
Hmm.
Sir, beg to state that the ground of arrest were not communicated to him, nor
Hmm.
to his family members.
Hmm.
And as such, there is gross violation of constitution and mandate under Article 22(1)
Hmm.
of the Constitution, as well as Section 47 and 48 of BNSS. It was not at all served with, which is evident from the notice
Hmm.
itself, which shows that the signature of the accused was taken instead of his family member. So far as notice under Section 47 is concerned, the petitioner states that the notice was supplied to the petitioner in English.
Yes,
language.
which part you are, we will not read the whole of it. Which part are you trying to say?
Here, their objection is that neither 47 nor 48 was complied with.
Are we restricted to that when you are looking into the fundamental rights?
Lordship, I am placing the ground taken by the petitioner that the notice was not served on his on English language also. That is also provided. in
We
the-
will reject that ground. With that ground, we will reject. We will say it is a wrong submission.
Yes, and then 48, Lordship, the wife was immediately informed and the
Informed of what?
about his arrest, Lordship.
That is what Bihan Kumar says will not do.
Okay.
About the arrest will not do.
Lordship, may
It
please
has to be the grounds of arrest.
ground of arrest because conscious position of he was arrested with conscious position.
The
of-
wife has to be, the relative has to be informed about the ground of arrest.
That we have not recorded.
You have done your best. Sir has done his best. We will do our best.
Obliged, boss.
Yes. You would have the order tomorrow morning, sir.
Obliged.
Tomorrow morning, now there will be positive time. If we keep dictating, others would have to wait. Not at this stage. Etu bhai thabo tate. Aru etu bhai dibo. Etu thoise. Etu bhai dibo. Etu bhai dibo. Ekhon beleg ke dibo. Satinda until to beleg etu 36. Yes. Next month. Aru keta man ase? 40 ta man ase ne? Huh? Yes.
Received the report.
Ah.
No case has been registered against the present petitioner at this school PS till date.
So, madam, we'll close this. We will close this, allow you to approach the approach as and when a police case is registered against you. Even that is not necessary. Sir. Yes, the learned APP has submitted that no police case has been registered against the appellant hearing, against the applicant hearing. On the instructions to the said effect have been placed before this court, which are kept on record marked as Annexure X. In such view of the matter, this anticipated bill petition does not require any further adjudication and the matter is closed. May be disposed of.
Please, Lord.
Here, what I have seen, Lordship,
Mm.
today is 132 days.
Mm.
Commercial quantity. So 180 days. Lordship, the question of
Not spoken about before get your lordship.
Yes.
and I have taken the instruction from the OC, Lordship.
Ah.
Indeed, send back,
Ah.
Lordship. And they have not yet procured the FSL report.
So the charge sheet is not there. So we can look into it.
Yes. So Lordship,
And your CD is awaited.
yes, CD is
And
available.
your CD is awaited, but then looking at the manner in which cases the things have proceeded in this particular matter, what do you suggest? We wait for the CD again, they will go say that we have again submitted a charge sheet.
Lordship, because 180 days is the mandatory period.
I understand.
Investigation is going on.
So if we have the CD, we can decide this.
Yes, so Lordship will fix it, that will produce the case then.
Lordship, it may prolong again, Lordship, already.
We
last
cannot
5 to
have it
6
tomorrow,
years-
the day after tomorrow, or tomorrow we are not fixing anything. At best 5. 5th, CD or no CD, we'll make it observation.
Lordship, a final chance, already 5 to 6 days CD has been awaited.
In criminal cases, it is so difficult to say a final
Otherwise,
opportunity.
my purpose will be
It is
vitiated.
investigation, huh?
default bail, I will wait for the default. My
Your
purpose will be
quantities,
different.
what were you doing?
The third day, Lordship, if I'm not wrong, Lordship.
No.
I may be wrong, Lordship.
There were more dates.
Play on our part, Lordship, because charge sheet was submitted. We had taken the instruction.
On 2 occasions, CD did not come. That is also a fact.
10 big cartoons containing one big cartoon tobacco like substance. Fifth, at the request of the learned counsel, or at the request of the learned APP, list this matter again on the 5th of January. The learned counsel for the petitioner has submitted that in the confusion regarding the receipt, the filing and the return of the charge sheet, several dates have already elapsed. Therefore, he prays for a early date. Full stop. Learned APP has assured that his diary in the matter would be made available on the next date of listing.
Can it be on 6th?
On the 6th, we have fixed 20 cases. The list would be overfilled because immediately after the vacation. The 5th, or then it will go again too long.
5 will be.
I can attempt.
Regarding the FSL report, Lordship had asked me. That issue is consideration before the full bench of the Supreme Court.
Yes, it has not.
It has not been
decided
decided
yet.
because there are
Whether the FSL,
Yes.
with or without the FSL report, would it still be a
different
complete
high-
charge sheet?
Different high courts have different view, but in respect of our high court, Lordship, a bench has held-
FSL report would say what is the substance.
Exactly, it is a.
Yes, Lordship, because what is happening, Lordship,
Contraband or not.
the main
It will
criteria
declare
is,
something.
Lordship, if the FSL report is awaited, then prejudice may be caused. But Lordship, in all the cases, there is a PP detection kit. If it comes positive, so no prejudice is caused. In that way, Lordship, FSL can be the view of the coordinate bench, Lordship. Otherwise, in Supreme Court, Lordship, it is still pending for consideration. Before the Supreme Court, it is still pending for consideration.
Unless the, এখানে তার দিব লাগিব এই আগৰ কেছটো খেয়াল চাব কেছটো নহয় এইটো কেছটো we are listing it on the 5th. 5th have the that also ensures the trust we fix
Yes, yes.
when we are fixing dates.
20.
Yes. বেলেগকে দিব মোৰ ভিতৰত কেছৰ কানেক্টেড নহয় তাৰমানে মোক কোনোবাই পঢ়াইছিলে মই পিছত কৰিম item 20.
May I please?
PCR received. Yes, sir.
Yes, in this case, your lordship, I am under
Arrested on?
detention from 1st of August.
Of August.
1st of August, your lordship. Now,
39 years, huh? Yes.
now here too, one question arises that section 48 notice. Here, of course, the 48 notice that has been shown here, but the no date has been written in the notice. And
What stopped the person receiving it from writing the date?
no date is there, your lordship.
Page?
Page 26 is to the wife. No date is present. Then, your lordship,
Do you deny receipt? Or have you given the date on which you received it?
we have received later on,
Accused nominated person has signed it. When did you receive it?
after 1 month.
Where? Where is the statement?
Para 8, your lordship.
Para 8.
Para 8. Para 9.
Para 9.
Immediately, we have received letter on that.
Where have you said 1 month?
1 month, we have not stated, but this is the fact, Your Lordship.
Were taken subsequently when?
Subsequent after 1 month, but that has not been written here.
It has to be subsequent to the arrest.
Yes, subsequent to the arrest,
Then
but not immediately. Because of that, they have not put this.
those
Yeah.
are grounds, those are factual aspects which will require them to swear and you to swear. We will not do that here. Yes.
Next, Your Lordship, whether the materials is a commercial quantity or not, that is the second question. Because if Your Lordship see the different documents shown here, they have put different quantity, different measurement of the quantity.
Okay, where is that?
If Your Lordship come to the FIR,
Uh-huh.
if Your Lordship come to the FIR,
FIR, yes. I will. Yes, FIR.
page 16, Your Lordship. Page 16.
Total weight,
Total
excluding
weight,
soap box, were found to be.
284.55 grams.
Ah,
Then Your Lordship come to the forwarding report, Your Lordship. Then in the notice,
just a minute. Then in the,
notice,
we have the forwarding, the seizure memo.
25, page 25, Your Lordship.
No, I'm reading page 23, 284.64. Then page 26.
Yes, 25th,
Yes.
284.55 grams. Then in the both the notice, then in the forwarding report, it is 284.64.
84.64 with boxes.
And here, Your Lordship,
No. 284.64 total net weight,
total net weight.
excluding soap box, was found to be 284.64.
Yes, Your Lordship.
Then in the forwarding, in the notice, it comes to be 284.55.
Yes.
It reduces. Like in the cinemas, there's a little bit of testing. So the testing that 0.9 grams, 0.09 grams. Then
Your
he
Lordship,
realizes we cannot do that. We should not test it. So he puts it back. Again, it becomes 284.64. That is what you are saying.
yes. Again, how it become
284.64. Yes.
284. Then, Your Lordship, come another aspect, Your Lordship.
At least 284 was found.
First, they found 284. 284 was found.
For 0.09 is not
Yes.
this. Even if we leave out that 0.09,
Yes.
284
Yes.
commercial.
284. Commercial.
Commercial. So no
Yes.
issue about the commercial part of it.
Now, there is
good.
another aspect, Your Lordship. Another aspect, Your Lordship. If Your Lordship come to the page 46,
Show us only what is relevant for us to consider the bail, sir.
Yes.
Not on the merit of the
yes, Your Lordship.
allegations.
So shortly, here, Your Lordship, page 46, total 284.64 grams without soft box, including PP transparent packets. Whether the transparent packets should have to be included or not. Because with the transparent papers, the transparent
How
paper
does
weights,
how do we decide your entitlement to bail on these?
because if you deduct the transparent part, paper part, then it may come to the lower than the commercial quantity.
34 grams.
Yes.
How many packets?
24 packets. And total 48 packets has been made. Total 48 packets. And
Any other ground, sir?
and I have gone through the
records, but I didn't find anything about the FSL report.
Hmm.
FSL report is probably there is no FSL report.
You would want this court to wait for the FSL report, or would you like us to decide it today?
Because what the FSL report says about the quantity.
Your first ground was
Was 48,
48. The date is not there,
that is not there.
but you do not dispute the receipt.
Yes.
Yes, sir. When how can we find out when she was served with it? From where can we find out? Dioksun TC এখন magistrate order থাকিব নহয়, they have been served with 48 বুলি ক'ব বা নাই বুলি ক'ব। ক'ব। Hmm. 48 BNSS was there on the date of their production before the remand court. So not a month later. Yes. Anything else, sir?
Sir, that is the ground number 8, Your Lordship.
Huh?
Because I am not involved in this case because the car is different persons. The accused, another accused is there, so it is his car. And
You were traveling in that car.
I am traveling in the car.
In what capacity?
He took me as a driver. And at that point of time, I am sitting backside of the car.
You are a driver and you are sitting on the backside.
Yes, because from Silchar it comes the car. So because of tiredness, I just give some time to drive the car to the owner.
Their lordship implicated lot,
Statement of which witness will implicate? What does it implicate? That he was driving the car?
No, I am not driving the car at that point of time. But the main is transparent paper, Your Lordship.
Huh?
Main is transparent paper, whether transparent paper includes the quantity or not. Otherwise, if it is
the rigor should not be there.
gram, if it is 2 gram, even then it will deduct to 48. 48 gram would be less. If 48 gram less, then it comes below the commercial quantity.
And where did the accident take place?
It is Lonka.
Where did the accident take place? Accident. Your car had made an accident. Where?
Hojai.
-84 minus
48.
Huh?
If we presume that 2 grams, even then 48, there is 48.
Even then at this stage, we do not find it a fit case. What to do? Await the FSL report or?
For FSL report, Your Lordship.
Await the FSL report. The trial court records are available. And counsel for the applicant has submitted that the FSL report is not available in the records. He prays for calling for the FSL report as and when the same is ready. List. Call for the FSL report will be submitted to the learned trial court. Call for the FSL report from the learned trial court as and when the same is submitted. Now we don't know when the FSL report will come.
View vacation. Let he remain. Let he remain.
List again on the 6th of February, along with the FSL report. He's not on. You are not on interim. You are in custody.
Behind the bar.
6th of February, Shubho. কোনটো কেছটোৰ লগত বৰ্তমান এতিয়া থাকক মই অৰ্ডাৰটো দি লওঁ কাইলৈ ৰাতিপুৱা ঘূৰাই দি দিব ৰাতিপুৱা দি দিব মই অৰ্ডাৰটো এতিয়া গধূলি লিখি দিম না not take much time. Yes, sir.
My lord, last occasion, my friend was directed to.
Respondent
take
number 2 in
instruction.
status.
Yes, Lordship, service report received, Lord.
She has been served.
Yeah.
None appears.
None appears.
Serial number 1 কোন আছে?
Here, the petition was arrested on 2/6/2025. And charge sheet has been submitted. And the informant has already been examined.
I know, Doctor, 17 years, 4 months.
More than 17 years.
Amicus may be appointed, Lord.
Huh?
Amicus may be appointed, Lord.
The learned APP has submitted that the service, as per instructions, the service on the respondent number 2 is complete. And appears for the respondent number 2 today. Therefore, this court appoints serial number 1 kunas. Huh? Do number 2. And D Gogoi. D. Dikit. Gogoi. As the amicus curiae in the matter. List this matter again on
Friday, my lord.
Huh?
Next Friday, my lord. Last time, amicus curiae come next Friday, my lord. It may be taken because more than 195 days.
Understand.
Friday is the last court, I think.
True.
It is very well.
12টা হৈছে দিব পাৰি এটা ৰিফ্ৰেছ কৰাই নাই নেকি Okay, on 19th, learned counsel for the petitioner shall submit a copy of the bail petition upon the learned amicus curiae. Submit a copy to the amicus curiae if you want it on the 19th. We don't want to go through the official process of someone making a photocopy and searching him out. You want it in a hurry, you do it. 1912. I'm
sorry, Lordship, item number 20, FSL report is there in the charge sheet, Lordship. I have the report, Lordship.
It is there, but we have already given a date. He wanted it on 6th of February.
Let it be on 6th of February, getting the FSL report, Lordship.
Later on, item number 20, later on the learned APP on going through the records has pointed out that the FSL report is available with the scan copy of the TCR. However, since the petitioner had made a request, the matter was directed to be listed on 6th. Matter remains listed on 6th. Eduki. আৰু 20টা 22 দিলো সেইটো মই মানে FSL ৰিপৰ্ট নাই বুলি কৈ দিলেতো মই নোচোৱাকে অৰ্ডাৰটো দিলো বিলিভ কৰি আছে FSL ৰিপৰ্ট Yes, sir.
This is a petitioner was arrested on 25/10/2025. So today is 61 days. First, before going into the facts, I'll just point out this petitioner is a 18-year-old boy. He's in higher secondary final. This time he's giving his final in February. Lordship, he was actually, the FIR was lodged by the father of the girl with whom she was his classmate. And they are having a love affair. And during that affair, they had some physical relationship. And ultimately, they had a fight. And after the fight, her brother who lost the FIR, has mentioned that he has released some photograph and videos to their friends in WhatsApp. And from them, the brother came to know that some photographs or videos were released by the friends. And thereafter, the FIR was given against him. Basically that. So there is actually the charges where even charge of rape has also been incorporated here, which actually is not a death. It's not a rape as such. I don't know whether the medical report is there or not. And secondly, your lordship, yes, the girl she's about 17 years, 9-10 months old, your lordship. So otherwise, she is just below being a major. And one section of 67B of the IT Act is also there. And
So the main sections are basically section 64(1) of the BNS, which is rape, which actually, your lordship, from the, even if your lordship goes through the FIR, which is at page 9, there's basically the FIR was lodged by the brother after coming to know about that some photographs were actually explicit photograph of his minor sister was uploaded in the WhatsApp group. It was a particular group of their friends where it was uploaded, and then the FIR was lodged. And in the FIR itself, it was stated that they had a physical relationship, and since there was a fight between the girl and the boy, he released that in the WhatsApp group. Basically, this is the overall story, your lordship.
She
Now,
has-
my prayer will be very limited to that. Expect that, your lordship. He is a young boy of 18 years, and very soon, about in February, I think his exams are there. He's a science stream student. Both are classmates, and that is regarding other part, your lordship, physical relationship and all and other things that I cannot say because
Will take its own course.
that will take your course. He
That
will
has to take
appear-
its own course.
He'll appear, your lordship, whenever required to, and face the trial, your lordship. Only two
That
sections.
he is a student from where do we find it?
He's a student of, I'm just.
The Mr. Sharma, we find Bhulote.
Yes.
The best way to try and protect.
And she's also not that.
Shimmering, huh?
She's
No, no.
just 17 years old.
The
That's just.
The-
He's, your lordship, that we have stated in paragraph 7.
not for us to say so, but that shimmering affection is still there. Bhulote gusi gol video. She's trying to shield. Yes.
Slightly different and
Oh.
183,
Mm.
that feeling is there also.
One,
As Lordship has pointed out. that
164 is actually more, that is the one. 161 is before the police. 164 is before the magistrate, which is more evidentiary.
No,
value.
that part is fine, but
Just this protection.
where do we find that he's a
60
student?
is the paragraph 7, your lordship.
Not about the paragraph 7. You'll have to give us something more, sir. You'll have to give us something more.
Yes. Certificate. just
Yes, madam.
School certificate is school certificate.
You have gone through the,
Not
you have
that
gone
is
through
the
the
WhatsApp.
statement. Otherwise, the
Says that some torture was met out to the victim.
he snatched the mobile and took away, and then he uploaded the photos after the fight. And before the police, yes, that is mutamoti the statement. But before the magistrate, we had photographs. We had a fight. He took the mobile, snatched photos with a few friends, and while sending them from my mobile, it was a mistake. Yes,
My lord,
yesterday we were
letter
with you.
had
Yes.
taken and copy served to the amicus curiae, my lord.
There's some exam.
My lord.
No, tomorrow is the date.
Yesterday was that, and today fixed
For-
lordship, and,
Ah.
and tomorrow is the date for argument, my lord.
For argument.
My lord.
Yes.
6 months, about 7 months, my lord. Only 4 days left to complete the 7 months behind the bar, my lord.
Yes, sir. What do you say?
But victim 12 years old, no?
No, 12 years.
Hmm?
My lord,
Victim is 12 years.
PW6.
my lord, regarding that, my humble submission is have a look on this page number.
Very
This-
quickly, yes.
My lord, 12 years not, my lord. They totally failed to ascertain the age. Age because even though there was birth certificate, but police did not seize the birth certificate.
True.
One school certificate had been seized. Later on, IO also adduced evidence. IO did not examine the headmaster or school, not visited to
Not
the
proved.
school.
Huh? Then.
My lord. So in the doctor's report,
Ah.
it was stated that 15 to 17 years, my lord.
Ah.
So in the FIR information stated that 12 years, my lord.
Mm.
So age is, my lord,
We will
not
take it
this-
to be the highest age, 17. Now tell us.
my lord, then 65, one not complied with, my lord, not abstracted.
65(1) maybe not
BNS, my
applicable,
lord,
huh?
BNS, my lord.
Something else is applicable.
My lord.
The innocence
My
is
lord.
not there.
My lord, my lord, the statement of actually, what was the actual truth, my lord? We have one copy from the learned trial court below, my lord. The statements of the accused, my lord. His statement, may I submit, my lord?
Quickly. I think you will have to await what comes from the
My
trial
lord.
court.
My lord,
You will have to await what comes from the trial court.
my lord, kindly please.
Malat, as in of the Malat trial, Malat for fixed for argument, Malat. Anything happen in here, Malat? 13 years old girl, Malat. Their statement of the to PW6 is the younger sister. He is 12 years, as per the statement. Victim is page 30, the 13 years old girl. Malat, may see her statement is page 31.
You await the judgment.
My lord, one judgment also, if my lord kindly look this judgment also. How totally negligence from the IO also, my lord, because regarding the age, my lord. Even in the judgment, my lord, Puttai versus-
He has switched on his phone and put the other arguing counsel online. Your arguments will now be divulged there.
My lord.
You will have
but
nothing to argue.
Even though I beg to submit one judgment of this latest.
No, we are on the bail part, sir. We are not on whether you would be convicted or not.
Of the victim is sufficient, my lord.
Huh?
Of the victim itself is sufficient, my lord.
Yes, sir. What does it say?
Uttar Pradesh, Puttai versus state of Uttar Pradesh, my lord. This two persons, one convicted life sentence, my lord, death sentence, one for whole life, my lord. Important parts is, my lord, para number 72, my lord. We look on.
This you argue before the trial court, sir.
In the cross part, we see more ascertain, my lord, kindly see page 32. In the cross.
My lord, very interesting, my lord. In that FIR, there was no date. In that date, on which date it was endorsed, it is also not. There is no forwarding report, a certificate not.
You are giving a lot of homework to be done to the arguing counsel tomorrow.
My lord. My lord.
Page 32, cross part, second paragraph. More from my lord. Today is fixed for argument, my lord.
Tomorrow is fixed for argument. At this stage, I will reject it and you'll have the other day after tomorrow. So tomorrow argue at peace.
Again, after my lord, if I will convict it, again come to the honorable court and to move and bail.
We will consider it then. Once it is convicted, we'll see about the sentencing part. No difficulty. Huh?
No, it is not 12. Yes,
some
doctor's
sanctity to
15 to
what we do.
17, my lord. Doctor's report says that.
Even if it is a 17-year-old girl,
My lord, it is true. It is.
the nature of the allegations perhaps is not possible with a 17-year-old girl. It is only possible with a 12 or 13-year-old.
My lord, accused says that 10,000 rupees had been taken as a loan, and on the very date, he was called to receive the loan amount. But interestingly, the informant and her husband not present in the house, my lord. Subsequently, this story developed and case has been
We
filed.
find a different story in this other bail petition we have already taken up, sir.
No, my lord. In the we have written in the para number 7, my lord.
Second, next item has already.
We are on different items, sir. Now the next item is going on.
P6. Master blessing.
Yes, dismissed. We don't say dismissed, we say rejected. Kundu. This was rejected. Item 56.
May it please your lordship.
Hmm.
Lordship, 480
Why
the
don't-
application for regular bail, my lord.
Ah.
And petitioner is behind the bar since 51 days, my lord.
Ah.
And the allegation is intermediate quantity, my lord.
Intermediate quantity.
Page 14 is the FIR, my lord. And
Huh?
page 14 is the FIR, my lord.
Hmm.
On last date, it was for.
CD is
FSL
here, sir?
report.
FSL report is still awaited, Lordship.
But 51 days, my lord. As on today, my lord. Considering the length of detention, my lord. At this stage, my lord.
CD is awaited. Why was he carrying that amount?
My lord, it was recovered from the house of another accused, my lord, which
Ah.
is, who is the prime accused, my lord.
Ah.
He was found in the house of the prime accused, my lord. Therefore, he was apprehended and forwarded to the.
Nothing recovered from this man.
In the seizure list, it was written as a house from the prime accused, Imdadul Haq, my lord.
Was present in the house.
He was present in the house, my lord, to visit his house. Page 19 is the seizure list. My lord. Authorized possession.
Mere presence in the house.
Lordship, otherwise 6.
Intermediate quantity in the entire house.
Lordship.
Huh?
The other person, Lordship, he is the prime accused. He is absconding.
But with the intermediate quantity. With the intermediate quantity. Lonely afternoon with friends, a cup of tea. Huh? Turn to something else. Can we consider or not? Huh? Intermediate quantity. Mr. So-and-so and counsel paying for the so-and-so. The counsel for the petitioner has submitted that according to the FIR itself, the applicant was present in the house of the person from where the intermediate quantity of contraband, namely, what? What was
4090.97 grams.
grams of
Ganja.
ganja was recovered. Full stop. The learned counsel for the petitioner submitted that he has already completed 51 days behind bars. The CD call for has been produced. It appears that the petitioner was present in the house and no material was directly recovered from him. In view of the above, this court is of the view that the petitioner can be allowed the privilege of bail. 20,000, 15,000, 2 sureties of the like amount. 30? 30,000. 2 sureties of the like amount. Yes, next. Disposed of.
Deeply applied.
Yes.
Has not been received, Lordship.
May I please your lordship? I am appearing on behalf of T-Som. Kindly please pass over it for a day.
Has not been received. He is only on interim, Lordship.
He is on interim.
Yes.
PDS rice.
He has appeared, Lordship, before the IO.
He has appeared. Any further custody required? Custody interrogation?
Difficult to say.
The petition, it has been submitted that the petitioner is under interim protection and has appeared before the investigating officer. Stop. Learned APP has sought for an accommodation to obtain the CD, updated CD list again on 2nd of February 2026 with updated CD.
It's submitted, Lordship.
And appears for the petitioner on call. Learned APP submits that the charge sheet has been submitted by CS number.
CS number 128/25 dated 30/09/25.
placed it again on 3rd of February. In her absence, we cannot even close it.
Here also, the petitioner is on interim bail.
Hmm.
CD we have lordship, but it is not up to date. So may I pray lordship an updated CD maybe also.
It has been heard Mr. Svensson and the council appearing for the petitioner. It has been submitted that the although the CD has been received, it is not up to date. Mr. Learned APP has sought for an accommodation. List again on the 4th of February 2026, allowing the Learned APP to have the updated CD. The interim protection granted earlier shall continue. Yes, CD was retained.
Yes, ma'am. This is the case, my lord, under GM Coke Industries. There is there is a quarrel between the parties, my lord. Among them, there is somebody have some receive injuries, my lord. That is the case, my lord. That is the case, my lord. There is a quarrel between the among the worker of these GM Coke Industries at Sonapur, my lord. And among the some of us got injuries, my lord. And that is the case, my lord. And the petitioner before lordship is not present at the dilemma point of time. So
He is who? He is the owner.
No, my lord, worker, my lord.
He is one of the workers.
The 3 persons, they are all workers, my lord. They are all on workers, my lord. And they are not name accused, my lord. The police, after receiving the police intended to arrest the petitioner and others. Some of them already been arrested and.
Anybody else arrested, sir?
Earlier some person who arrested, my lord. But the thing is that, my lord, here ultimately one person was died. One labor died subsequently. 103 subsequently added. Now, here Ramkumar Mandal, Ajay Kumar, Anil Kumar, 3 persons are there. One Ajay Mahato was there. One Ajay Mahato earlier subsequently perhaps arrested. He was there. But, my lord, there are statement of several persons. When clash was there, them said that moi mara manubilok chini napao jodi Ajay, Ram, Madan, Manish buli koi aha shunisu. So these persons are malak directly
not implicating.
Directly, I have seen one Ajay Mahato. He was there, but he is Ajay, not Ajay Mahato. One is Ajay Kumar. And one is Ram Kumar Mandal, Anil Kumar. So
we can allow them to go before the IA, give their identification.
Yes,
then the CD can be updated. We can look into it. Whether these were the persons, this Ram and Ajay.
Otherwise, Malat, directly cannot say that they were not there or.
So therefore, let them go before the police. Something will come up in the case diary. Heard Mr. BP Sinha Learned Counsel for the petitioner. Also heard Mr. KK Parasol and APP. The CD as required has been received. The Learned Counsel for the petitioner submitted that given an opportunity, they would appear before the investigating officer to participate in the investigation. Learned APP has submitted that though there is no direct implication on the statement of the other people, other witnesses, the names in short appear at various places in the circumstances. We deem it fit. This court deems it fit to allow the petitioners, to direct the petitioners to appear before the investigating officer within a period of 7 days from today. On their appearance, if they are arrested, they shall be released on bail on furnishing a bond of rupees 10,000 each with one surety of the like amount. Subject to the satisfaction of the investigating authority, updated CD may be called for by the Learned APP. List the matter again on the 6th of February.
Okay, so
6th of February 2026.
Lordship, in this case, I need some time to file the objection, Lordship.
Who is she, madam? Who is she? On what basis is she appearing, madam?
I'm appearing, Lordship, as a support person.
Yes,
because,
support, High Court rules and the CRPC, my lord, doesn't allow, my lord, a support person to be heard.
At best,
May
she can assist the people.
Assist.
May I submit
May I,
lordship?
my case, my lord,
May I submit lordship in this connection? Because I'm appointed to, because informant is the minor. So I'm appointed by CWC as a support person, lordship. Informant is a minor.
let me place my case, my lord. If you,
CD received.
let me place my case. If your lordship feels, my lord,
Anyways.
may it please your lordship. My lordship may kindly turn to page 11, the FIR, my lord. May I read? Hello? My lordship have gone through the FIR, my lord. Now, my lord, that person, my lord, Munu Khura, my lord. The person who is named, my lord, Munu Khura, his name is, my lord, the petitioner, my lord, Manos Pratim Datta. Now, who is Manos Pratim Datta? Manos Pratim Datta is the cousin brother of the father of the informant. My lordship I made it clear, my lord. Now, your lordship may kindly turn to, my lord, our additional affidavit, my lord, at page, my lord, 34 for a month, my lord. Additional affidavit, my lord. It starts from page 26, my lord. The order, page 26, not sure you got it, my lord.
Yes.
There is an order of 7/6/23, my lord. There is a dispute between the parents of this informant, my lord. On matrimonial.
Both the parents had fight is what we
Yes,
understood
my
from
lord.
the FIR.
Now your lordship will turn to page 34, the operative part. Below, my lord, in regard to the visitation right of the respondent father, the following order is passed. The aggrieved mother shall have temporary custody of both the minor children until further orders. The respondent shall have the right to visit both the minor daughters only on weekend, that is Saturday and Sunday. So this was the order passed by the JMFC. Now your lordship may kindly turn to page 40, sorry, my lord, page 45, my lord. The mother, my lord, again filed an application, my lord, before the magistrate below, my lord, to, my lord, this application was filed, my lord, on just a moment, my lord. I'm sorry, my lord.
This is by the wife.
Sorry, my lord. Lordship, kindly turn to page 62. 62, man. I'm sorry.
62.
62. I'm sorry, man. Really sorry. 62, my lord. This is an application filed under section 25(2) of the Protection of Women so and so, my lord, for alteration, modification, and revocation of the order dated 7/6/23. So the right which is given to her father, my lord, to visit,
She
my
wants
lord,
to take it back.
she wants to, my lord, modify it. On what ground, my lord? Then lordship will turn to page 67 for a once. The petition she has written, my lord. Page 67, my lord. From above, my lord, fifth line, my lord. There was Mama, Peha, Jethai, both cousin Pahi, etc. so and so. No one came to stop my dad. I was crying all alone. Asmi Ba, age 17 years, was also one, saying them, let go, but Papa did not listen to this. I felt so bad on one time coming from the health. Now, lordship, my lord, this is the all below lordship may come. Last 4 lines, my lord. I was crying. I was feeling much hatred towards my Papa and Jethai. Then Koka suddenly said, my lord, that your lordship will read, my lord. I cannot read in the open court, my lord. My lord, the allegation against the, my lord, uncle, as well as the, my lord, the Koka also, grandpapa also. So, this FIR, my lord, cannot be, and if your lordship goes to the FIR, my lord, but it says, my lord, second line, at the end of the ceremony, one person, so and so, touched my shoulder and then tried to touch my breast in drunk condition. Only touched the, my lord, shoulder, my lord. Lordship, I got it, my lord. So now the case is registered under, my lord, section 8 of the POCSO, my lord.
You mean, your plea is that it is a false case?
False case, my lord.
False case arising out of some other,
Because of dispute between the mother and father, my lord.
okay,
And-
we have the
and-
CD?
And one more submission, my lord, small
Yes, sir.
submission, my lord.
Yes,
Its
sir.
lordship goes to section 8, my lord. Case is registered under section 8 of the POXO, my lord.
Mm.
So section 8 says, my lord, whoever commits sexual assault, my lord.
Mm.
Now the question is the definition of sexual assault, my lord. Sexual assault, your lordship will find the definition at section 7, my lord. Whoever with
Mm.
sexual intent
Ah,
touches
the
the, my lord,
intent
those
part.
parts, my lord.
You will be on the intent part.
I'll leave it to your lordship, my lord. It may be at a best a case of 12, my lord.
Kindly produce the statement of witness.
Mm. It is almost a repetition of the entire affair.
I have flagged my lordship statement of witness.
Huh?
One witness lordship. I have flagged my lordship. Kindly.
Okay.
That function, all the family members were there, lord.
Is 97, no?
Mm. Yes.
And one last submission, my lord. My lord, as the informant is a minor, obviously the notice should go to the mother or the father, my lord.
Will go.
POXO case, my lord. So in the instant case, my lord, yeah, I have filed another affidavit, my lord,
Mm.
that your lordship will find at page 96, my lord.
Mm.
An affidavit sworn in by the father of the informant, my lord,
Mhm.
page 96, my lord.
Mm.
The affidavit, my lord, it's the operative part is at page 97, my lord.
Yes.
Yes, my lordship will see the from first paragraph, my lord, that I am the father of the informant.
Mm.
Second paragraph, my lord, that there is a long history of matrimonial dispute between the mother of the informant, namely so and myself, that the mother of the informant in the aforesaid PS case has manipulated her own daughter to lodge of
Ah, yes. You read it.
my lord. It's a dispute between the mother and father, my lord.
I'm appearing on behalf of the support person. Support person is being appointed by the CWC to assist the victim. And here victim has lodged the FIR. So I'm appearing on behalf of the support person. The mother and husband and wife dispute, that is a separate and it was
Are you
continued.
under instructions from the informant or from the mother of the informant?
No, I got instruction from the informant.
Informant.
And informant also need, after I received it on Friday evening, the case details, and thereafter I called upon the informant to come here, to come to my chamber so that I can have clarification on a few things. Then the informant said that, example,
Before,
this is the reason I took some time.
before.
So I prayed at the outset to give me little time so that I can
clarify some of my, this thing with the
All-
informant, and then I can file my objection.
Thing is, when she is a minor,
Yes, Lordship.
she would not be filing an affidavit.
Yes, or affidavit will be, this thing will be filed by the support person on behalf of.
Support. Now you are not the natural guardian.
Yes, Lordship.
So you would not be putting up the affidavit. We will not be accepting an affidavit from you as we understand the law now. You may convince us otherwise, but that is the law we understand. A child will have a natural guardian or a legal guardian. You are neither. You support her outside the court, number one. Number two, the statement recorded by the investigating officer of two of the witnesses. We are not concerned. We just went through it to see whether they remain consistent or whether the stories are plausible, not plausible. We have also gone through the statement of the victim girl under section 180. Okay. Now we find certain aspects of the assault missing. We are being frank with you because you are the support person. The statements have been already recorded.
Yes, Lordship.
We try to decide on this issue.
Yes.
Certain aspects of the assault part is missing. Number one, and number two, the grievance more appears to be that my father neglects and ignores me. Not on the mother, but on
Yes.
my father is one person who does this. I am very unhappy. When the statements recorded which come up here essentially do not point out that part of the law. The words are very carefully chosen. Someone tries to touch on the neck. He tried to touch on my neck. I did not give my consent. These words have to be fed to a 14-year-old. Is it not?